seminar series under Dr. B.R. Ambedkar Chair, International Academic Chair. This is a proud and historic moment for all of us, as the seminar marks the first national level academic event under the chair. As we gather here today, we remember with deep respect Dr. B.R. Ambedkar, whose vision and ideals continue to guide our academic and social pursuits. With your kind permission, we may now proceed to formally begin the introductory session. On this occasion, I invite Sri Sudeshan, Director KILA, to deliver the welcome address. Thank you, sir.
Very dignitaries on the dais and my dear friends. Education is the most powerful weapon which you can use to change the world. With these words, I may say good morning to all of you, because this is the words of Dr. Ambedkar. This academic event is organized by Ambedkar International Academic Chair, which was established and inaugurated in the previous months. This is the first of its kind in Kerala. Under a government department, in a training institute here, an academic chair was established in the name of Dr. B.R. Ambedkar. That is what is called Dr. Ambedkar International Academic Chair. This event is organized by this academic chair. The chair is established to honor Dr. Ambedkar's legacy, focusing on education, including academic resolutions like policy research, fellowships, policy document preparation, social dialogue on the topics, specific topics on human rights, social justice, women empowerment, and the empowerment of the voiceless people. The chair also is envisioned to promote an environment to create Ambedkar's democracy, where Ambedkar democracy is a place where social justice and equal opportunities are recognized and approved in a society. This is a proud moment. I would say this 2 days program, this academic program, would be recorded as a historic moments in the trajectory, educational trajectory of Kerala, for 2 reasons. This is the first beginning of annual academic lecture series in Kerala. This is the first time. After the death of 60 years of, I think 17 years of the death of Dr. B.R. Ambedkar, we are starting for the first time in Kerala an annual lecture to commemorate Dr. B.R. Ambedkar, the father of the Constitution of India. If you look at the chair, as I said, the vision of the chair, after the 77 years of the Constitution, so it took 77 years to establish a Ambedkar chair in Kerala even. That itself shows the political scenario of our country. So the Ambedkar chair explains a lot. I think it will be deliberated in the coming sessions also. So my job is to make the welcome speech. So time is very important. I want to keep the time, so I don't keep long. We have with us the very chief guest and the chief speaker, Justice Chandru sir. He is a retired judge of the Madras High Court. He has all the way arrived from Chennai to deliver the first Ambedkar lecture. He is very familiar to Kerala. I think he is very familiar to all of us. But I think a special introduction is required. He was one of the finest constitutional judges in this country. The word constitutional judges is more important in the present ecosystem of India. Who is a constitutional judge? A constitutional judge is a judge who adheres to the principles of constitutional values. Of course, we have wonderful judges in our higher judiciary. We have wonderful judges, eminent jurists, excellent judges in our higher judiciary. But we don't have enough constitutional judges in our country. That is the difference between judges and constitutional judges. So it is my honor and my privilege to welcome Justice K. Chandra sir to this event.
On this occasion, I invite Director General to adorn short.
Okay, sir, please do. So we have also with us our Director General Nizamuddin sir IAS. It is his leadership and his initiative which made this event happen here. So I extend a warm welcome to Nizamuddin sir to this event. We have also with Thomas sir, excellent academic person. He will attend in the coming academic session. I also extend a warm welcome. So we have also with us some academic persons with us, so I extend a warm welcome to all of them. So we have the students from various colleges. So with love and affection, I welcome each one of you to this event. You are the real attraction of this program. I extend a warm welcome to all of you. Before concluding my welcome speech, I would like to mention 2-3 points about the whole agenda that we have set out for the today's business. Totally, we will have 6 academic sessions, business sessions. First is naturally the first annual Ambedkar lecture by Chandra sir on a specific topic, constitutional morality and the vision of Dr. Ambedkar. That is the topic on which that Chandra sir is going to speak. That topic is very important in the present day India. I think, sir, recently the Honorable highest judicial officer of the government of India, Solicitor General, made a very shocking argument in the Supreme Court that the constitutional morality should be buried. That is the ecosystem that we have in our India. So I think sir will speak on more on that thing. So that is the first topic. So the students have also the opportunity to respond to his sections. Okay. So our second session is social democracy in Ambedkar's view. Gender perspectives of Ambedkar thought. That is the second academic session. That session is important because Dr. Ambedkar may be the first person in India who wrote about gender justice in our India before independence. Actually, he wrote about gender justice in 1930. In his writings, we can come across what is gender justice. So that topic is very important. So I request the students to be more participative in that session. The third session is social democracy in Ambedkar's view. What is the connection between social democracy and political democracy? Without a meaningful social democracy, we cannot sustain a meaningful political democracy. So you can also respond to that session. Fourth session is equity, justice, and governance. So today we will have 4 academic business sessions. Tomorrow we will have 2 sessions. The first session, the caste system and the Indian social life. That topic is very particular in the present day Kerala also. So some incidents occurred in the Anjarakandi government college is a thing to be deliberated upon here. You can use that opportunity also. That the last session tomorrow, constitutional perspective of ethics in governance. These are the 6 topics that we are going to deliberate upon in the 2 days. So I conclude by reminding you the very purpose of this academic event. The very purpose of this academic event. Let me tell you the very purpose of this academic event by 2 questions. How much Dr. Ambedkar is close or beloved to the citizen of this country? This is the first question. How much? I repeat. How much Dr. Ambedkar is close or beloved to the heart of the citizen of this country? Second question. How much Dr. Ambedkar is valuable to this nation and to the world? how much Dr. Ambedkar is valuable to this nation and to this country. Because it is Dr. Ambedkar who is the person who educated the people of India what is the value of dignity, what is the value of a dignity, what is a dignified man. It is Dr. Ambedkar who taught and who educated the people of this country what is the meaning of dignity. So with this, I conclude. Unfortunately, Dr. Ambedkar has been labeled as a Dalit leader alone. Dalit leader alone. It was I think I would say it was a conscious effort from some parts. Of course, he is a Dalit leader, no issue. But he is more than that. He is more than that. W or EW, he is more than that. So we should learn it. Ambedkar or Jai Bhim is a slogan, is a movement, is an icon, is an idea, is a justice. So we want to deliberate upon all these things today. With this, I conclude. Thank you.
So thank you, sir, for warm welcome. With due respect, I invite Sri Nizamuddin, IAS, Director General, to deliver the presidential address.
A very warm good morning to all of you. Respected Justice K. Chandru is a retired judge from Madras High Court and an eminent speaker also, and a Sri V. Sudeshan, who has delivered the welcome address. My colleagues, the academic professors who are going to take the class in the coming sessions, the dear participants and others. Actually, it is a privilege for me to be here in this important function. Why? Because since I have taken charge as Director General KILA in 2024 July, the idea of initiating an academic chair in the name of Dr. B.R. Ambedkar came before me, and over the last 2 years, we have been trying to establish this particular important chair in KILA campus, because many of them were wondering that why KILA should take an initiative to initiate this particular chair in KILA. Normally, this kind of academic chairs are initiated in universities and other higher education institutes. But we thought that since KILA is closely associated with the local self-governments and also the general public in transforming the local governments and also the general public towards the local governance and implementation of more activities at the grassroots level, we thought this particular chair will definitely be a way forward for the initiatives of KILA and also the basic objectives of KILA also. And fortunately, we were able to get all the permissions by last January, and we are proud to say that the Honorable Minister of Finance in the state of Kerala, who is also the member of the Legislative Assembly from this particular constituency, Sri K.N. Balagopal, he has declared in the state budget that the state will provide the financial assistance for taking forward this academic chair. So, based on the declaration of the state budget, KILA has taken all the initiatives and we have started the chair. I hope you might have visited, or if you have not visited, you should take your time and see how the particular chair has been installed, wherein we have the exhibition, the library, everything is there. Rather than initiating a chair, it's not an issue of just starting a chair and just keeping it unutilized. So we thought that right from the beginning, we should start some activities. Normally the state government, as you all know, now since the elections are over, all are waiting for the new government to come, whether the government is going to continue or a new government is going to come or what is going to happen, nobody knows. So almost all the departments are keeping ideal. But we thought, since the anniversary of Dr. B.R. Ambedkar is on April 14th, actually we planned to have it on April 14th itself, but as you all know, because of the series of holidays, it will be very difficult. So the next day itself we have planned, and I'm very happy to say that we are in the first lecture or the first Ambedkar lecture, which is going to be continued. I can assure you that it is going to be continued in the coming years, and this is first of its kind, and we will have a series of lectures in the coming years also. And we are also very proud and we are very happy also to have an eminent person like Justice K. Chandru here, as Sri Sudeshan has pointed out. So the first lecture, and that too in the topic constitutional morality and vision of Dr. B.R. Ambedkar, will definitely give the way for the coming lectures also, sir. So we are really proud that you are going to initiate this major initiative of KILA. Not only KILA, it's for the state of Kerala and for the people of Kerala actually. So the entire state looks forward for the activities what we are going to do there. Actually, the establishment of the Ambedkar chair at KILA, what I personally feel is a meaningful step in carrying forward his ideas and ideals of and the relevance of on the local governance actually. Because KILA is an institute wherein we are supporting the local governments, and we are doing research as well as development studies in the field of local governance. So the views of Dr. B.R. Ambedkar in the field of local governance will definitely be a major building stone for KILA also in the coming lectures also. And we also reinforce our commitment to embedding the constitutional values at the grassroots and ensuring that the governance is truly inclusive and participatory, which Dr. B.R. Ambedkar has visioned while constituting the Indian Constitution. It should be an inclusive governance. So definitely as an institute working in the field of inclusive governance and also local government, working with local governments, this will be the major priority of KILA in taking up this particular lecture. I don't want to take much of the time because eminent person is here who is going to give you a lecture. But as you know, the KILA as a premier institution in the field of local governance has been in the forefront of building capacities and fostering innovation in the decentralized planning and development. And we are proud that the first lecture is being is inaugurated, or which is going to be delivered before the upcoming generation of Kerala. Normally we take up this kind of capacity building activities or trainings or lectures before the local government representatives. But we thought that this should start with the younger generation or the upcoming generation or the people who are going to take the Kerala forward in the coming centuries. That is why we decided that this lecture will be focused on youth, particularly who are studying at different colleges as well as universities. And we are very hopeful that you will definitely be the torchbearers of this academic chair throughout the Kerala, because I am very happy to see that children or students from all over the state or from different districts are here. So you will definitely be the torchbearers, and also I request you to be the ambassadors of the Dr. B.R. Ambedkar chair which is installed in KILA. Then we all can hope that the vision of Dr. B.R. Ambedkar can be achieved to some extent. I am not telling that it's going to be achieved at 100%. To some extent, through our small initiative in KILA and through you, after going back to your institutes, you can definitely be a part of this in the coming years also, and we will move forward with the upcoming generations also. To conclude, I use this occasion not merely to have a moment of reflection, but as a call of action which I have told you. This is not just hearing something from the eminent speakers who are going to give you the lectures. After the lecture series, we are having 3 technical sessions and also another panel discussion followed by a special lecture also, in addition to the Dr. B.R. Ambedkar lecture series. By hearing these lectures or these sessions or interacting with the eminent speakers, we should not go back barehanded. We should have a call of action. What we are going to do for the upcoming year, we will take just 1 year. What we can do, what is your suggestion? What do you expect from Dr. B.R. Ambedkar Chair to do in this particular field, in the field of educational institutions and also to the youth? I assure you that as Director General of KILA, your thoughts, your ideas, your suggestions and your reflections will definitely be included in the action plan of this year, and we will take this forward in the state of Kerala, and definitely you will also be hand-holded, you will also be associated, you will also be a part of this Dr. B.R. Ambedkar Chair, and let us move forward together to take Dr. B.R. Ambedkar's vision to the extent possible, what KILA can do, what youth of Kerala can do, and what the state of Kerala can do, so that by our activities, let the government feel that Dr. B.R. Ambedkar Chair has its own role in the social sector of Kerala, in the development sector of Kerala, in the governance sector of Kerala, in the socialization of local action plans in the Kerala, which Dr. B.R. Ambedkar has visioned years back. So let us be the beginners of this particular thing. And once again, I thank you all to be here, and also assure you that your thoughts and suggestions and views will definitely be the action plan for the 26-27 academic year, wherein Dr. B.R. Ambedkar Chair is going to finalize the activities. So hope that you never take this as a seminar, you never take this as a lecture, but you take this event, this first Dr. B.R. Ambedkar Chair lecture series as a call of action for the young generation through you who are the representatives of the future Kerala. So once again, thank you very much. And I once again thank Dr. Justice K. Chandru, who has taken much effort, for this lecture. He has traveled from Chennai to here. So, sir, once again, I thank you on behalf of KILA and also the state of Kerala for taking your effort to be here. And we'll definitely be thankful to you for starting this lecture also, and you will also always be remembered in the future of Dr. B.R. Ambedkar also. And also I thank all the academic speakers who has come right from Kannur University, University of Kerala, from People Abhiyan, Haryana, then Srinarayana Open University, MES Asmabi College, Kodungalur, Srinarayana College, Kannur, MG University, Sanskrit University. So you can see that you have a different spectrum of speakers who will share their views, and let us have a 2-day, I don't want to call this as a workshop or seminar. Let us have a 2-day very close interaction and interchange of ideas of older generation and younger generation, and we will jointly take Dr. B.R. Ambedkar Chair forward together with all sectors of the people. Academicians are here, researchers are here, preachers are here. Local self-governments are the only people who has been left out. Definitely, your suggestions will be the next lectures will be for the local self-government representatives immediately after the election process is over. So we'll handhold the elected representatives also, because they are the main stakeholders of KILA. So I don't want to take much of the time. Once again, I thank you all to be here, and I humbly request Justice K. Chandru, retired judge of Madras High Court, to deliver the Dr. B.R. Ambedkar Memorial Annual Lecture, the first of his series, and the topic is constitutional morality and vision of Dr. B.R. Ambedkar. Over to you, sir. Thank you. Thank you.
So one request is there. Sir's speech is given us not in the welcome kit. Please go through it. Refer.
Jai Bhim, I'm not canvassing for my film. Jai Bhim is a famous slogan which was conceived when everybody was shouting Mahatma Gandhi ki jai, Pandit Nehru ki jai. Then people thought, why not for Ambedkar? So it's a Jai Bhima Rao. And I'm very happy that I'm with you on this great topic, constitutional morality and vision of Dr. Ambedkar. I will not read my paper. I have prepared a paper and circulated in advance. I wish the papers is circulated to you. You can read leisurely. You can also ask questions by writing the questions and send it to it by the end of the lecture. And I'm sure that this seminar will draw more response from the audience, and that's the only success for any seminar. And before I go to the topic, I must tell you the protocols which are now adopted. First they gave me a flower, then they gave me a shawl, and what is the significance of all these things that you should understand? The other thing that was absent was that we don't have a lighting of lamp. That is also there in some other places. Ultimately, when I became a judge, most of this so-called respect have become symbolic. In fact, I put a board in my office room. There are no idols here, no flowers, nobody is hungry, no fruits, nobody is shivering, no shawls. So that stopped all this arrangement. And this I practice very strictly because some of these formalities have become, on the period, makes totally a meaningless exercise. You take the case of this shawl. I am not showing any disrespect. This shawl, how it began, people putting shawl. You must understand, these are not rituals. The putting of shawl was started with a towel, that too a khadi or a handicraft towel. Why was it put? I remember this started in Tamil Nadu. The idea of putting a shawl, not a shawl, but a towel, a cotton towel, on the shoulder is because for centuries, some communities cannot wear any cloth over their shoulder. And they used to, even if you have a shawl, used to tie it on your hip and not put it on your shoulder. Even today, in some other villages in Tamil Nadu, when the Dalit people come, they'll have to remove their headgear or the towel and tie it in their hip, whether it is a case of respect or a social hierarchy. The Dravidian movement started the campaign before the start of every meeting that we'll put the shawl over your shoulder. You know, the southern part of Travancore, even women were not allowed to wear their upper cloth. And there was a movement for that. And there was also resistance for that. And these are all issues when the shawl became a symbolic gesture where the communities were hitherto not allowed to wear were ought to wear on the top of their shoulder. This was a defiance. This was a symbolic defiance of the caste hierarchy that was imposed on them. And slowly, the Qadar and the Khadi gave way to this kind of shawls and became more respectable attire. But one thing is, we never wear this other time. Our climate is so bad, not a single time you can wear this anytime. Now, over the period, these kind of symbols, people forget the theme behind the symbol and use it for this. After my retirement, in fact, the present Chief Minister of Tamil Nadu, he started adopting, he in fact issued a circular that nobody should put any shawl, nobody give bouquets, nobody should give fruits. Instead, they must give the book. This became a very important campaign because in the last 5 years, when he was a Chief Minister, when this campaign started, he has collected more than 4 lakh books, 400,000 books, which were circulated to all the district libraries. Immediately it goes to different libraries, and it has become a campaign of a literacy campaign. And these symbolic protocols have given away to a more of a literacy mission, and I think this should be one of the important lessons that we should learn. Every small move has its own repercussion. For example, our Chief Minister went to Pudukkottai district, and there was a lady collector, her name is Kavita Ramu. So she gave a book. As usual, most of the collectors now only give book. So wherever we go, they give a book only. And then if the book is already read by me, I send it to some library. And it's something like a knowledge sharing. That way, this Kavita Ramu gave the Chief Minister a book. And it just ended like an ordinary reception. But then the papers took a picture. And then you start zooming. What is the picture? What is the book? The title of the book was The Unknown Part of Christianity. It is in Tamil, written by a women author, Niveta Lewis. It is not something in praise of any Christianity. It's also pointing out the negative trends within the religion. But then, for the media, it's more important that the district collector gives a book on Christianity to the Chief Minister. As usual, the Bharatiya Janata Party started a campaign. How can the district collector give a Christian book to the Chief Minister? This was one of the issues. And then, next day, the local BJP party went and gave a new book, The Thoughtful Hinduism, to her. And that became a news. Now the problem is, people who don't read books, they start attacking the books. People who have nothing to do with the books. In fact, our local BJP leader claimed, he was an ex-police officer, he claimed that, that he has read 20,000 books. Now, it makes no sense. I asked him, if it is 20,000, why not 20,000 plus 1? Is there any ceiling for books? There is no answer at all. And this campaign went on. In fact, I spoke in Pudukkottai district. I said, the people who are afraid of books are the fascists. The people who deny anybody a reading of a book are the people who try to deny the real knowledge for the common people. It is in that sense, it should become a regular campaign. And I will stop with this introductory campaign. When I'm applied, I'm coming to Kerala more often, and I came to Arivipuram for a function. You know where is Arivipuram, and some of you would have seen the place, some of you would have read the place. It's a place where Narayana Guru established a Shiva temple. Establishing a temple, everybody established temple. The point is, anybody can go touch the idol. Anybody can go do the offer, which became a complete change in attitude. That Kerala is the first place where that this social reform movement also became part of a national movement. It's just not for political independence, also for a social change. The program for which I was invited to Arivipuram was a science jada by the Science Forum, and they want to take the scientific temperament to the people. because there was a human sacrifice reported from Kollam, and the Kerala, such an advanced state, if there is going to be one reporting of a human sacrifice, it becomes a national news. Therefore, the Kerala Science Forum wanted to start a science jada from Aruvipuram, and then it went up to middle of Kerala, Thrissur, and this is something we keep doing. There is no ceiling, there is no finality to such enlightenment. From Aruvipuram, I will go to Yalanir Madam. Yalanir Madam is in Kasargod, and I don't know how many of you, some of you are a law student, you must know what is Yalanir Madam. Yalanir Madam is a mutt established by Keshavananda Bharati. Anybody who is familiar with Constitution knows who is Keshavananda Bharati. Keshavananda Bharati is a Swamiji, not that he is a social reformer. When the Kerala government wanted to take some lands from the mutt, and the land acquisition was questioned, saying that you can't take the land just like that, it belonged to the mutt. The matter went to the Supreme Court, and there were a lot of differences within the Supreme Court. It always happens. 2-judge bench, 3-judge bench, 5-judge bench. Last 5 days, there is a 9-judge bench on the very much on the Shabarimala. This bench discussion, which Krishna Iyer called it as a number game, it goes on. So the Keshavananda Bharati's case, matter went to a 13-judge bench. Supreme Court today has got 34. At the time when this 13-judge bench was constituted, the total strength of the Supreme Court was only 16. Almost every judge of the Supreme Court sat in the bench, heard the case. It was a property-related case. In fact, this Keshavananda Bharati died 2 years back, and all the papers wrote a big news on that. You might have read it or not read it. Keshavananda Bharati's news came not because of his mutt, not because of his spiritual work, because he was one of the litigants in that batch of cases. The case went into the larger question whether Constitution can be amended. The previous judgment said Constitution can be amended. There were some judges who said Constitution, including fundamental rights, can be amended. Now this is a step by step. After all, Constitution is meant for common people. It has been amended 106 times. Even now, there is an amendment pending since yesterday. The delimitation and women's reservation. 131st bill is pending. It is not a scripture. It is not a Bible. It's not a Quran. It's not a Bhagavad Gita. It can be amended. Now, in Keshavananda Bharati's case, the majority judges said, you can amend the Constitution, you can amend the fundamental rights, but you cannot alter the basic structure of the Constitution. Now, the basic structure is a term which is not found in the Constitution. It is judges' invention or judges' restriction. Judges said, you amend everything, but not basic structure. Then what is basic structure? Now, this is a very important issue. The judges could not list 1, 2, 3. Each judge said, in my opinion, this is the basic structure. This is the basic structure. They gave some 6, 7 examples. The first basic structure is a preamble of the Constitution. That we, the people of India, give ourselves this Constitution to make India as a sovereign democratic republic. Now, the sovereign democratic republic was the original term. Now it has got 2 more words, secularism and socialism, added in the year 1976. Now, the basic structure. Why preamble? Now the Kerala government is giving copies of preamble to all the school children, because this constitutional spirit has to be understood by the children, and therefore the first page is shown to everybody. Now, what is the other basic structure? It includes parliamentary democracy, judicial review. It goes on like that. Now, when they put a rider that you cannot amend, including the preamble to the Constitution, which is a basic structure, it imposes a check on the executive. It imposes check on the parliament to make certain changes so that there is a stable constitution. Now the question is, who is supreme? Are they not separation of powers? Are they not power defined between the legislature, executive and the judiciary? Our Chief Justice Gawai, somebody asked him, sir, do you think Parliament is supreme or High Court, Supreme Court is supreme? He said that's an irrelevant question. I am not going into the issue whether Parliament is supreme or the Supreme Court is supreme. What is supreme is the Constitution of India. Now, therefore, we work within the corners defined by the Constitution, and therefore, it is more important to understand the basic structure theme for which, incidentally, the Elanir Mutt became a party and Kesavananda Bharati became a landmark judgment in our Supreme Court decision. The Supreme Court decision given by 13 judges is still rules today, and therefore, we are guaranteed with one guarantee that the basic structure can't be tampered with. Basic structure include preamble, which includes secularism, which includes socialism, and therefore, Elanir Mutt, the other side of the Kerala, is more important. And I keep going to Kerala often. I went to Mancheswaram campus of Kannur University for a lecture. My lecture was over by lunchtime, and my train was only in the evening at 5 o'clock. So there was some 5 hours gap, and the distance is only about 40 minutes. But the people told me, you just go now itself to Kasaragod, because there is going to be some traffic jam. I was wondering, what is traffic jam? There is only one road going to Mangalore, and why can't we cross? No, there is going to be a protest. So I wanted to see what is the protest. Even I don't mind missing the train. I was watching in Kasaragod. There was a line of women from Kasaragod to Trivandrum holding hand to hand, the human chain. They didn't call it as the human chain, Mahila Madilugal. I was surprised because 670 kilometers, the women of Kerala holding hands, standing from Kasaragod to Thiruvananthapuram. What is their demand? Is the demand for some extra gas stove or an extra gas cylinder or a demand for some extra payment? Only one demand. If we want to see our Sabarimala Ayyappan, that's the only demand. We want to see our Ayyappan. I was very surprised because several lakhs women standing in one side of the road throughout the territory of Malla. It got reported in Kerala papers, but not in other papers. One of the unique moments in the Indian history where women, the entire border, could stand 670 kilometers with one demand, that we want to see our garden. Now, who will answer the question? On the day when the women were standing in the Mahila Madhulagal, the law was very certain. A 5-judge bench in Supreme Court said, you can't exclude women from worshipping Ayyappa, irrespective of age. If you try to prevent, it's a violation of Article 15, 17. 17 also they have said, because 17 abolishes untouchability. In all forms, they said this is one form. In fact, 1 week before, Justice Nagaratna, when the case began in Supreme Court, 9 judges were sitting. Out of 9 judges, there was only one woman. And that one woman asked that question, you can't make women 3 days untouchable, 27 days touchable. Where is the law? This is one question. Now, most important question is, why is that there is another judgment? Why is there another case? What happened to the 5-judge case? Now, 5-judge case has gone to 9-judge case. Somebody filed a review application. This Sabarimala judgment should be reviewed. Now, the review matter is now 9 judges are sitting and 1 woman judge is hearing. It's all right, we are not worried about that. It is not what is written in the Constitution, it is what the judges say. And therefore, we will have to listen to the judges. The first argument of the central government, where the Solicitor General, Tushar Mehta, he made the argument, we cannot accept the doctrine of constitutional morality being pressed into service every other matter. Therefore, we should review this judgment, which is based on morality. Now the question of morality becomes important, because where do you get this morality? Why is that the word morality comes in? Morality is always understood as part of a theological exercise or a spiritual exercise, never as a law-making exercise. Law is very clear in its own form, but then the morality is added. Should the law have a morality? And more important, should the constitutional law have a morality? Now, in fact, Justice Krishna, describing the Constitution, you know, he always invents new words. He's very innovative. He said, pachydermic parchment. What is pachydermic? What is parchment? Pachyderm means elephant. Parchment means paper, elephant paper. Constitution is the mother of all laws, and therefore it became elephant paper. It's written in a huge paper. As usual, our Constitution with 395 articles and 12 schedules, one of the lengthiest in the whole world. It is certainly an elephant paper only. But more important thing is, does the Constitution talk about morality? And why is that we are now discussing constitutional morality? Now this is one question that comes, and therefore the topic of my today is a constitutional morality. And then where does the Ambedkar comes in? Dr. Ambedkar, did he ever use the word morality anywhere in the constitutional framing exercise done by the Constitutional Assembly? These are the two issues. I think you circulate the paper. I think my paper is being circulated to you. I will not read the paper. I will only say, since I started with the slogan Jai Bhim, now does Ambedkar has any relevance today when we discuss this topic? This is one issue. Now, after my retirement, as usual, all the retired judges used to give lectures, used to read some articles. This is what we do with no other exercise, because this is the only thing we can spend time. So I had lot of time, and I never went to court thereafter. And I started collecting all the judgments which I delivered on the issue of women. I published a book, the Listen to My Case, which has been translated in 7 languages. Then the other collection I made was on the question of religion, on the question of caste. These issues sometimes keep coming, and when we are in Tamil Nadu, it comes more often. And when we sit in Madurai bench, more and more such cases do come in to court hearing. When I collected out of the 96,000 or cases which I disposed of, it was about some 300, 400 matters relating to religion and caste. I combined all of them, make them subdivided into different topics on religion, on public employment, on the right to reservation, on several issues, right to worship, so many things, right to food. Now, what is the topic that you give it to the book? This was become more than writing the book. Giving the title to the book become very important, because it should be catchy. Even when we took the film, Jai Bhim, in 5 languages, we didn't have a topic. We want to have a topic which can immediately attract. So finally we said, we'll give a Jai Bhim. And that became one of the major success, was that immediately today people say Jai Bhim. So in my book on caste and religion, and I gave the topic, My Judgments in the Light of Ambedkar. That's my topic. And I published it. I know it will invite controversy. And as usual, one of the television interviews, one provoking anchor asked me the question, Sir, you are a High Court judge. Your judgment should speak on Constitution. How is that you are saying, my judgments in the light of Ambedkar? Then somebody will say, my judgments in the light of Golwarkar. I said, I don't care what others are saying. Today, if you want to speak on caste, if you want to speak on religion, you got to read Ambedkar. Without reading him, without understanding, without absorbing Ambedkar, you can never write judgment. In fact, in my judgment, in number of places, I have quoted extensively the quoting of Ambedkar. I always used to wonder, am I the only person who is quoting Ambedkar in a judgment for a guidance? Recently, in 2025, Supreme Court has given a judgment which you must read. Sukanya Shanta was a Union of India. In that judgment, at least in 8 places, the Supreme Court has quoted from Ambedkar for a guidance, and I should completely absolve, or I should completely redeem of any such accusation, because it has been proved that if you want to speak on caste, if you want to speak on Ambedkar, you got to read Ambedkar. There is no other way. You can read Constitution, you can read any kind of commentaries, but without understanding that you can never speak on Ambedkar. And it is in that sense, let me begin today's topic. Last month, precisely on March 20th, I was invited for a meeting in Mahad. Mahad is a small municipality, about 100 kilometers from Bombay. What is Mahad? What is March 20th? You must ask the question. On March 20th, 1926, Ambedkar convened a conference in Mahad. The conference was a conference of scheduled castes. At that time, the word scheduled caste was not there, so they always use the word conference of untouchables. The untouchable conference was held in Mahad. What is the demand? In the Mahad, there was a tank. Tank is maintained by the municipality. You know, under the 1920 Municipality Act, all the public tank and public places are vested with the municipality for maintenance. Once it is vested with the municipality, there can never be any discrimination. Anybody can make use of the tank. The tank is not meant for the upper caste. The tank is not meant for the Savarnas, and the Avarnas are left out. Now you know the difference of Savarna and Avarna. In the four-tier caste hierarchy are the called Savarna. Those who are left out of the caste system itself are the Avarnas. Now the Avarnas are not allowed. Why? They will pollute. Is the pollution born with them? Is the pollution is a birthmark? Now Ambedkar asked the question, why is that when everybody else can make use of the tank, why is that we are now prevented? It is a municipality which is collecting tax from everybody, is maintaining the tank, in Saudar tank. We will enter into the tank and then we will take water. And then when they tried to enter the tank, there was an attack and somebody filed a case in the sub-court Mahad, and the sub-court granted an injunction. You will be surprised. Are they all courts of justice or courts meant for some other purpose? In 1927, the Mahad sub-court granted an injunction against the Dalits from entering into the tank. That stay was there for some more time, and finally in December, on 25th December, there was a victory celebration. The stay was vacated. People entered into the tank and took water. And in justifying the entry into the public tank, Dr. Ambedkar said, it is not just water we can get from anywhere else. It's a question of a right of a human being to be treated as another human being. It is in that sense, our temporary entry movement, our tank entry becomes a symbolic issue of demanding a human right to be equal to any human being in this world. Now, most important was in the March conference of 1926, I think next year we are going to celebrate the centenary of that tank entry, and this is the 99th year, and therefore I was invited to that place. Most important was the last day of that conference. Ambedkar took a book and then burned a copy of the book. And you know what is the book? Book was Manusmriti, which we call as Manu Dharma. There is no Dharma about it. Manusmriti is a caste code, the caste hierarchy, and what each caste is expected to do, what is the Dharma of a caste, and if you violate the caste discipline, what will happen to you? It also has sanction. It's a penal code also. It's not just a Dharma code. Now it is in that Dharma that the caste restrictions are put very clear terms and what is meant for some. Now when he burned this, there was a huge publicity. In fact, such a thing could never be even contemplated today, but it happened 100 years ago, and the first man to do was Dr. Ambedkar. And in that historical speech, he said that it can never be a dharma which denies justice to a substantial section of the people. Now the word dharma, the word or a caste code, Is it being uniform to everybody? Is it being or selective to somebody? This issue is coming, and it is this understanding, this centenary. In fact, we will be celebrating the second centenary we have already celebrated, is a Vaikam. Many of you would have gone to seen Vaikam on the way. Vaikam is not a temple entry movement. Vaikam is only going by the street adjacent to the temple, that's all. There is no sanctity. Certain section of the Kerala people were not allowed to walk on the streets. Now the question is why they can't walk? When I can walk, when he can walk, why they can't walk? Now this question, when it raised in a larger level, it led to a movement to deny this. Why should we ask this question? It drew an all India attention. Vaikam is a very small place, but then the entire India, the Vaikam became an issue because a section of the people were not allowed to walk in the streets. Now when the movement started growing, when the newspaper reports were going, Mahatma Gandhi, at the time one of the greatest leaders, he wanted to visit Vaikam. He always thought it is easy to persuade human beings. Therefore, persuasion is possible. He also believed the Hindu Dharma. He also believed in the caste Dharma. He said, maybe there are wrong interpretations, but then we should also respect this system. So he never allowed anybody else to enter into this area. So when he came here, he spoke to the Orthodox people of Vaikam, all the recorded history. In fact, most of you, what you should do, more than listening to us, you should read all those documents. It is relevant even today, even after 100 years. A centenary of Vaikam was celebrated last year, both by Kerala government and by Tamil Nadu government. Now in the talk between Mahatma Gandhi and the Orthodox people of Vaikam, which lasted for 8 hours, which is all recorded there. Finally, Mahatma Gandhi, who believed in scripture, who believed in the system, asked them one question. I want to ask you, where does it say in your Dharma Shastra that people cannot walk in a public road? He asked one question. The answer was more compelling answer was, it is need not be written in any code. There is something is faith. My father believed it. My grandfather believed it. My great-grandfather believed it. And therefore, I need not question their faith. I need not question their belief. We continue to follow the belief. Therefore, Mahatma Gandhi ji, please don't ask about Shastra. And the talk ended in a failure. Later led to a very important protest. Finally, the Maharaja of Travancore issued a decree that anybody can walk in that way. Kerala became one of the landmark area where such equality doctrine has been accepted. Now this question keep coming. When Tushar Mehta, Solicitor General, asked that question, that do you think that the constitutional morality should be a doctrine to interpret the Constitution? Can it have an independent effect than what has been enshrined? If you think that the religious right and the religious practice, in a way guaranteed by Constitution, where is the question of the court interfering in the matter of faith? This was the argument. Then the judges, one of the judges, the Chief Justice of India, you must read all this. You can even see it's being live streamed, even the entire argument. You must watch all this because it's the first time you will be hearing 9 judges hearing what is religion, what is the religious practice, what is the reform, what is the constitutional right of the parliament to make reforms into a religious practice. All this you can hear. The second argument, the judges said it is very difficult for the court to say which of the practice of a religion a court can interfere. This is one issue. And therefore, the faith becomes an important issue. And within that faith, what is the constitutionally guaranteed faith and what is not the constitutionally not guaranteed faith? This is another question that comes in. And therefore, the morality question comes in. Does the constitutional morality makes people to understand that such faith can also be interfered with? Now this argument, which I could even give a Kerala example, the North Malabar, which was part of the British colony, unlike Cochin and Travancore, which was the princely state, the North Malabar, more particularly Guruvayur temple entry became an issue. Can you see Lord Guruvayurappa? No, you are all untouchable, you cannot have. So this became an important issue, whether all the people can see or not. There were people believed entry of the scheduled caste will pollute the temple and therefore they can never be allowed. Now, this question started becoming an important issue. The first thing was the government was, which is the British government, which did not want to enter into this area because they have enough problems and therefore they don't want to alienate the local population. But the population itself, the opinion was divided. And therefore they said as a SOP, as a solution, we'll ask the local devotees whether it could be permitted or not. So actually an election was held among the believers of Guruvayur temple, whether temple entry can be open to everybody. It so happened progressive state like Kerala and a progressive population voted that nobody to be denied and they can be allowed. Now this was an issue. When these poll results came, somebody again went to court saying you should not allow these people. And finally, when the litigation was dragging, the North Malabar Temple Entry Act of 1927 was passed. That was the first time a legislation came in. Before the legislation, there was also the so-called undertaking of understanding the people views. Now this is the precise argument which is now being argued. What happened 100 years ago in North Malabar, now being pressed into service in the central Malabar area, saying you cannot interfere in the faith because the constitution do not. The question of constitutional morality comes in. Does constitutional morality has got an independent stand? Does it can a constitutional morality override a faith of a particular denomination? Now this question comes in. Now it's the Supreme Court, at least in 3 earlier occasions, you must have read as students of criminal law, the first case was section 377, unnatural sex. What is natural sex and unnatural sex? This question comes. Then who decides what is natural and what is not? If the nature itself produces people whose sex identity cannot be definitely predicted, can there be a third gender? There is a third gender. Undoubtedly there is a third gender. Now what is nature? Now this 377 IPC was enacted into the IPC in 1860. As you all know, Lord Macaulay, being the law member of the board, drafted this. The draft was ready in 1837, but it could not be made as a law because there was opposition within the East India Company saying that you suddenly bring a law, local people may be objecting to it, and therefore a lot of when Queen Victoria became the Empress of British India, this act was notified. But the idea of 377 was borrowed from the English law, English penal law, and it continues to be there. Now when the constitution comes in, you can strike down a legislation if it is an arbitrary exercise of power. If a law makes a crime which is arbitrary, it can be made as a, because Article 13 of the Constitution enables the Supreme Court to decide every law, whether pre-constitutional or a post-constitutional, whether it is circumventing with the, consistent with the fundamental right. And therefore, for the first time, the Delhi High Court in Nas Foundation case held that you cannot make something crime without actually meaning it was a crime or not. The preferences of sex is something can never be made as a penal offense. And therefore, the Delhi High Court, Justice A.P. Shah, Chief Justice, said the constitutional morality, he used the word constitutional morality, cannot be to make something crime which is not a crime. Something to make the people to be afraid of when they need not be afraid of. What happens within the four corners with the consent of parties can never be made as an offense. And therefore the Delhi High Court judgment became a landmark judgment. In fact, one of the High Court judgment which was reported all over the world. And many people started asking questions that the Indian High Courts have become mature enough to decide the law as a law, not based on extraneous consideration. And this was challenged in the Supreme Court. And Supreme Court took a very quick route by saying whether something should be a law or not is the Parliament concerned. We cannot interfere with the law made by the Parliament. Actually, IPC was not made by the Parliament. It was a pre-constitutional law. But then the Supreme Court struck down the Delhi High Court judgment. Then again the matter went to, by another method, went to a 5-judge bench. Now the 5-judge bench ensured the very Nas Foundation case was a correct decision. They decriminalized 377. Now the 377 is gone from the IPC. It's no longer a crime. It may be something moral. Now the question of moral, what is called the social moral and the constitutional morality, which will prevail. I have a moral. My mother, my religion tells me like this, or my faith makes me like this. You can have 1,000 amount of morals. Ultimately, what is prevail is a constitutional morality. Whether your law can be acceptable as a civilized form of notion. Now the Delhi High Court judgment was upheld by Supreme Court by pressing into service the constitutional morality. Now the question is, increasingly, the constitutional morality starts attending. The next question was adultery, 497. Now, you know, I need not describe what is the offense. Now it's something very peculiar to our penal law. Supreme Court said in Joseph Shine case that it can't be a crime, it can be an offense, it can be a misconduct, it can be a conduct which can lead to a dissolution of marriage, but you can't jail people because they try to do something which is not acceptable to the society. Between a social morality and a constitutional morality, it was a constitutional morality which prevailed, because the social morality is not static. It cannot be left to some Victorian era of values. Values keep changing, and therefore we keep changing. Now 497 gone, 397 gone, 2 judgments are there. Now the question came, when the new penal code came, Bharatiya Nyaya Sanghita, 377 is removed, 497 is removed. Now the Parliament accepted the Supreme Court dictum and removed these 2 provisions from the penal code. Now in the Nyaya Sanghita, they are no longer there. Notwithstanding this fact, the Solicitor General is arguing day before yesterday that the Nas Foundation is wrong, Joseph Shine is wrong. We cannot adopt a constitutional morality as a yardstick for striking down some of these provisions and decriminalizing them. They are arguing. Now my question was, is the central government standing lawyer, is he arguing for himself? He is arguing for the Union of India. If he is arguing for the Union of India has made the law only in 2023. They have accepted the Supreme Court judgment. They have not made it anymore a criminal offense. Now how is that the argument? Therefore, today you will find arguments based on opportunism. Now if you want to strike down Sabarimala, you will have to remove constitutional morality. That's as simple as that. Now he says, constitutional morality cannot be a ground for the purpose of deciding legislations. It is always left to the Parliament or legislature to make law. Now this is the first question that is coming. Now this 9-judge bench, when they finally decide one way or other, we will have to see whether constitutional morality is a question which can be accepted in the constitutional field of law. Now did Ambedkar ever discuss about this morality question? Now if you read the entire constitution, 395 articles, there is only one article talks about moral, that is Article 25, that too relating to religion. In relation to religion, they say that religious practices is subject to morals. Now, who decides the moral standard? This is one question. Now, Dr. Ambedkar, knowing fully well, in the constitutional debate, he puts the argument that a pure legal text may not draw much attention with the executive or with the legislature unless it is added with some more masala, some more flavor. He said we should have a morality, a constitutional morality to adhere to these norms. Now that is how the word morality comes in. There are many people who did not agree. Even Mr. K.K. Venugopal, in one of the lecture, which I have quoted in my paper, said, the faster this doctrine dies is better because Supreme Court will become a third chamber. That's a standard argument because they always make the court as a blame point, saying the court is now making legislation. Court makes several times legislation. We don't want to go into the other issue. But a particular legislation made by the parliament is consistent with the provisions of the constitution, more consistent with the legal principle. Now the question of morality is read in one place, that is there in 25. What is constitutional morality? This is another issue that you will have to discuss, and that is a vision of Ambedkar. Dr. Ambedkar were very clear on one issue, that if you leave it to the faith of the people, the faith is again based upon numbers. The number based upon majority and minority. Then what happens to the minority? What happens to the minority faith as opposed to the majority faith? Therefore, he says it cannot be left to the majority or minority faith. It cannot be left to the vagaries of numbers. It should be something more on a constitutional level of a morality, which morality standard will have to be set by the court so that the common people will understand the text of law with more reverence. As you know, we have a morality. We always, in fact, as a student of degree, I was studied in a Catholic institution. We have a moral science class for the people who have no faith. For the people who have faith, or what is they call as the laity and the non-laity, they'll have a catechism class. Because Article 29 says, when a minority religious institution runs an institution, you can have admission of all students, but you cannot have a religious teaching to the non-believers. That is the constitutional bar, and therefore we are always divided into two forms. Today, if you ask any educational planners, they'll say, we must have a moral science. Everybody is agreed, nobody says there is no moral science. Does it mean religious imputation? Does it mean religious instruction? Never, nobody except because Constitution itself doesn't permit. Therefore, there is a clear division on the question of moral. In fact, Dr. Ashok Mitra was the finance minister of Jyoti Basu government. He has even given lectures in Trivandrum. In one of the lectures, he talks about private ethics and public morals. The question is, we have a very low moral standard. In fact, in S.R. Bommai case, Supreme Court says, of late we are seeing a decline in public moral. Therefore, it cannot be left to subjective opinion of the people. It should be left to a level where there is a constitutional standard. Your moral can change. Each day it can change. Yesterday it may be an offense under 377, unnatural sex. Today it may not be an offense. Still the morals require you certain standards. Adultery may be an offense yesterday, today it's not an offense, but still it may be a ground for divorce. Therefore, there is a difference between a social morality and a public and a constitutional morality. The constitutional morality is not based on faith. Constitutional morality is based on certain constitutional standard. Now I am very stressing to this point was, untouchability is abolished. Article 17, everybody will say that. Article 14 talks about equality before law. 15 talks about non-discrimination by the state. In fact, there was a Hindi film, title is Article 15. Somebody asked the director, there are 395 articles, why you are picking up 15? He said, perhaps under the Indian constitutional structure, the greatest of the article is Article 15. For the first time, the state declares that I shall not discriminate anyone on the grounds of caste, religion, sex, language, descent, or any one of them. Was it not there before? You take the case of any Mughal rule, you take the case of British rule, you take the case of Hindu Rajas, Have any of one of the state ever said, I will not discriminate on these grounds? For the first time, maybe after 20 centuries, it was the first humanitarian effort that the Constitution of India said that I shall not discriminate on these grounds, which means there were discriminations earlier. There were discriminations on these grounds, depending upon the rule. And now this director says that is the heart and soul of the Indian Constitution. Article 16 talks about non-discrimination in public service. Article 17 talks about untouchability, abolition, all forms, and Parliament can make a penal law. Now, despite all this, those things have not been abolished. That's a different issue. Most important was when the Constitution was being framed, it was not a very elected house. They were conscious of that. And then they said, why not we go to the public and show them the draft? We are making 2.5 years of debate. Hundreds of arguments are being allowed, page after page. Why not we tell the people, this is what our draft. Finally, the draft of the Indian Constitution was published. And each one, and the copies, number of copies that were sold in 1948 was 1,15,000 copies at the rate of 1 rupee per. It was sold. Once it goes to the people, there are so many opinionated groups. There are so many people who write letters. All these letters are in the archives of the Constitutional Assembly. Today, any research student can have access. Two research scholars went and made a research. What was the opinion or the suggestion or the protest that was received from the public of India? And they were able to make a book, very interesting book, which I have quoted. In fact, a very important book. It gives the psychic of the Indian people. Very, very, very shockingly, when the Constitutional Assembly circulated the draft of abolition of untouchability, some group from Kumbakonam, that's in a temple town in Tanjavur district in Tamil Nadu, a Mother Sangam, a women's organization, write to the Constitutional Assembly, please don't abolish untouchability. Why? Just like people are deaf, just like people are blind, just like people are dumb, it's a sin, and they let to suffer the sin. Can you believe in 1947, an enlightened group writes to the Constitutional Assembly, don't abolish untouchability. If this could be the opinion in the 20th century, what could have been the result earlier? What could have been the disastrous result it had on the society? Now this is all record. I have quoted that letter in my paper, which you must read. Why I am saying that was, it is not enough to leave it to the faith of the people. To say that this is my ancestors, my fathers, great-grandfathers believed, and they must have believed something which they must have considered more sacrosanct. Why I should defy? This hierarchical understanding of society's understanding must be demolished. And that is why Article 15 is a complete answer to this kind of argument. When Ambedkar in 1926 burnt a copy of Manusmriti, in 1949 he was able to produce a draft, this entire thing will be abolished. And therefore I keep on saying that the Constitution of India, more particularly Article 14 to 17, is a standing monument for a social justice and a complete burial of Manusmriti. I don't say this. You read in Suganya Shanta's case, Supreme Court says this. These vestiges of casteism must be buried at all costs under the touchstone of Article 15, and the court must take an active stand on these issues. And that's what the court says. And therefore, when you talk about the vision of Ambedkar, this is the vision, which he burned one draft copy. After 20 years, he is able to show that will be the constitutional law for India, which constitutional law people did not agree on their own. Will the Kumbakonam Women's Organization write, it's like a sin and they should suffer the sin? Will anybody write like this? Today, will anybody? They may not write today, but they may have the same sentiment. And that is why people are still arguing, you cannot interfere in faith. Yesterday, Tushar Mehta tells the court, you cannot interfere in the faith. And the Chief Justice of India replies by saying, we agree that the courts are not the arbitrators to decide whether the faith is bad or right or wrong. Now, this is another question that comes in. It is in that sense the constitutional morality takes a precedence on interfering or interpreting these provisions of it. It is not as if religion can never be interpreted. Article 25 talks about social reforms. Without the social reform, will you have a widow remarriage? We would have abolished sati, where a woman is burnt alive along with the husband. Now where is the faith comes in? Now the faith continues to be there along with these lines, and therefore faith becomes a disturbing point where the court will have to decide based on the constitutional morality. And therefore the government is now arguing that 377 judgment is wrong, 497 judgment is wrong, Sabarimala judgment is wrong, therefore don't interfere with the faith. Now the faith becomes an issue, most important issue, because again the question comes, majority or a minority. Now the majority or a minority question comes in because if you are going to say faith, then what will prevail is a majoritarian faith. That is why Ambedkar very clearly wrote that we can never accept a question of majority. If you think in a democracy, in a republican democracy, minority do consider matter, then the faith can never be the answer. It should be something more, a morality question comes in. And therefore the constitution stand apart from your faith. Constitutional morality overrides your faith. If you just see, I'm not transgressing. In the Ram Mandir temple case, they were to build the mandir in the same place where there is a mosque. Who gave them the right? 75 years of litigation. Finally, if you read the judgment, Ram Mandir judgment, you must read because it's a very lengthy judgment, at almost 1,000 paragraphs. In the 997th paragraph, the majority writes, in fact, who wrote the judgment, nobody said. It was only a unanimous judgment, but anonymous judgment. When the judgment came out, I wrote in a paper, this is a draft of Dhananjay Chandrachud, is a member of Supreme Court judge. Everybody said, how do you know? Today it's very easy because you have a computer, you can always feed, you can take all your previous judgment, you can see all the words, you can always identify, this must be your text. I can never disown my own text. I can find out. After a long time, Dhananjay Chandrachud became a Chief Justice and he also retired. In one of the interviews he said, when the judgment was resolved, we were having a lot of difficulties. What should be our decision? Finally, God saved us and we wrote the judgment. I wrote him, when the God himself is a party before you, if you read Ram Mandir judgment, the first party is Ram himself. Lala, Allah Ram Virajman. That means minor Ram as a body corporate files the case. I asked him, sir, did the very plaintiff came to your dream and said to decide in his favor? He won't reply, that's a different issue. But then I wrote to him, if you read the last paragraph, in all transfer of property matters, you need to have document, you need to have a strong proof, you need to have original document. Now in this case they say, the undisputed evidence that for 500 years a particular sect have been offering prayer itself is a standing proof, therefore the faith succeeds. The faith, they didn't use the word mere faith, I would put within the bracket majoritarian faith. If majoritarian faith are the only relying point, in this country there won't be any democracy. Democracy is a consent between the majority and the minority. It can never be the bulldozer majority. Now you have a bulldozer judgments also there. In fact, bulldozer has become a judgment. In re bulldozer, if you read law journal, there is one judgment which says in re bulldozer. How can there be a judgment on bulldozer? Because you bulldoze everything. If you don't like him, just bulldoze. Bulldoze his house. Yesterday also one house was bulldozed because he did something. Now Supreme Court says you can't bulldoze without these norms. Without these restrictions, people will keep on bulldoze. And therefore Supreme Court puts a restriction. But the same restriction is not put in other ways. Where faith succeeds, there won't be any democracy at all. And therefore Ambedkar insists the morality becomes important because minorities in this country should also have a say. That the people who adhere to the Constitution should also have a reverence to the Constitution. Not a very abstract letters, but a reverence, and morality brings that reference. You may not accept it as a legal language, but nevertheless he says, notwithstanding the legal language, morality is an issue. And therefore the vision of Ambedkar is that vision. And in fact, Ambedkar also very clearly says, I don't know, Ambedkar is a very learned man, which I need not tell you. Several languages he knows, and he knows Sanskrit, and he has read Valmiki Ramayana. And he gives a small example. In the Valmiki Ramayana, there is a story of Sambuka. It's not a story of Rama and Sita. There are so many sub-stories. One of the sub-stories about the Chambuga. Chambuga is a person who belongs to untouchable group. But he wants to learn Vedas. How do you learn Vedas? There are no schools. So he goes and listens to wherever there is a Veda being recited. He goes and listens secretly and then start memorizing. And one day he is very confident that he has learned Vedas. But then the people don't like it because they go and tell this man has learned contrary to the caste bar. What is the punishment? If you learn something which is not due to you, molten lead will be poured into your ears. That's the punishment given in the... Therefore, Champuga is produced before the Ram's assembly, that court. Then the inquiry is conducted, whether he has learned Vedas contrary to his caste code. And it has been proved. What is the punishment? Just cut off his head. And he was given death sentence by Rama in his own court. People always used to say, if Rama is such an avatar, Rama is such a great man. If you go to UP, even the UP Muslims refer to Rama as a Maryada Purusha Rama. They don't say he's avatar, but it's a Maryada, he's entitled for a respect. And then people ask the question, why is that Rama did not show leniency? Why there is no compassion? And Dr. Ambedkar answers this question in his essay. He says, don't blame Rama. Rama is a Kshatriya king, and he has to dispense justice, and justice based on caste code. Manusmriti is the law under which you dispense justice. What does the Manusmriti says? If a person cuts across the caste, disregarding his birth, the punishment is given in Manusmriti. If you want to blame Champuga's murder, blame Manu and not Rama. He comes to the rescue of Rama. Because he's a king, he dispenses justice. I always used to say, sir, why you gave a judgment? I said, we can't create law. We have to create only dispense justice. Justice is according to law. If the law is bad, my judgment is also bad. But I am not become a bad judge because I am administering the law. It's as simple as that. So he says, if you want to abuse for unfair treatment, abuse Manu. Now this is a very important question. When he burnt 100 years before a copy of Manusmriti, when he keeps on talks about the caste justice is opposed to human right values, when he finally writes Article 17, despite so many opposition, that is the vision of Dr. Ambedkar. And that is why when we talk about constitutional morality, it sets standard of a higher standard of a morality, not a moral of the society. He takes the issue to a higher morals and talks about vision. He talks about India as a future vision. With your caste division, India can never improve. You are talking about growth of India. You are talking about superpower. With all your hands tied, your legs tied, will you grow? And that is the question that he poses. In fact, I will conclude by two examples. Now the question was very simple. Now, I am asking a question. You have Ambedkar statue. If you come to Tamil Nadu, you will see a lot of wire fence. There will be lock and key. A man who guaranteed fundamental right. A man who guaranteed, at least wrote, that you have a right to speak. Article 19, a right to liberty. He is now put in a cage with a lock and key with the police. Why? Why a constitution maker? In fact, when you say about constitution maker, there are many people. There is a judge in Madras High Court who says, what is there in the constitution? All copied document. 1935 Government of India Act is copied, 70% copied. Ambedkar gave an answer. In fact, I wrote a letter to the judge. Please read more Ambedkar, then understand. He says, people say I have copied. I will not apologize to any such person. In any administration, any structure, the structures will be same. You may have a parliament, you may have a court, you may have a prime minister, you may have a president. All this is not copy. What is important of Ambedkar is Article 14 to 17. A structure which is built on unjust foundation. A structure which was been adhering all these years on unjust premises is being destroyed. That is Ambedkar. And now Ambedkar asked one question. If Ramayana, which is written by a backward class person, Mahabharata, which is written by an untouchable, why is that in writing the constitution they did not choose some upper caste? They chose only this Mahar, who is an Ambedkar. He very proudly says, and the contribution of Ambedkar is so high that we should have a greater respect for him. On the contrary, what we do in Jaipur, if you go to Jaipur High Court, in the front of Jaipur High Court, there is a statue for Manu, of all people. In India, only 2 courts have got Ambedkar statue. Only Madras High Court, other one is Supreme Court. Last year they started after a lot of demand. For a person who drafted this constitution, for a person who is the chairman of the drafting committee, you have only 2 respect. But then you have a Manu statue. Has anybody seen Manu in this country? In fact, people say there may be more than one Manu because there are so many interpolation in Manu Smriti. There may be more than, but then they made a statue. No protection, no iron cage. He stands with great security. What security? Nobody will touch him. 6 years back, in 2019, 2 women bravely got into the statue and poured tar on his face. And the policemen arrested them and took them to the station. And the statement was recorded from the 2 women. The women said, 1/5 of the India has been kept away from his code. Do you think he is a Dharma Shastra that is written? How do you call him as a Dharma Shastra? How do you call Manusmriti? Will we ever accept him as the embodiment of law and justice? And therefore we pour tar. Now this question I keep asking because this morality question we have never understood. In fact, last year, I think in the month of August, the Chief Justice of the Madhya Pradesh High Court. Madhya Pradesh is a huge state. There are 4 High Courts. One High Court branch is in Gwalior. In the Gwalior branch, they want to start an Ambedkar statue. And the Chief Justice sanctioned it, and a statue was made, brought in a lorry to the Gwalior High Court gate. 87 lawyers, most of them are Brahmins, very senior lawyers, lied at the gate and said, we will not allow Ambedkar statue in our High Court. And the lorry was standing there, 2 days of hang-banging. Finally, the lorry went back and there is no statue. I am asking the fundamental question. If lawyers who learned law, the lawyers who studied constitution, the lawyers who studied various systems of law, the lawyers who also imbibed the constitutional value of equality and non-discrimination, how do they prevent a statue of Ambedkar? Now that is a fundamental question. If you want to have constitutional morality, if you want to learn a vision of Ambedkar, one lecture is not going to do. This may be the starting lecture, but more important is each one of you should read Ambedkar, not my speech. I read Ambedkar because I was able to deliver a number of judgments. In fact, my book is available, even in Malayalam translation is available. You should read every one of the cases which I have described. That today we are standing on a crossroad. Today we are standing on contradictions. The contradiction is, on the one hand we have equality, on the other hand 1/5 of the Indian humanity is left away. 37 crore of the people are not denied, they are denied the equal status in this country. People may say, no, that may be in rural area, that's not in Kerala. India is not Kerala. India is not Tamil Nadu. India is a vast country of 147 crores. Even today, if you say 1/5 of the humanity is denied their natural right, their inalienable right of a constitutional right of being recognized as the Indian people. Now, in that sense, I think much more things to be done. I am happy that your institution has started a lecture on the name of Ambedkar, and I think this exercise should keep coming. It's not mere lecture. Ambedkar books are available today for anyone to read because for a long time they were not published. After his death, there was a dispute. So the entire collection of his archives papers were not under litigation. Finally, the Bombay High Court original side entrusted the matter to the Bombay government, the entire archives of Ambedkar, and Bombay government constituted a committee. Only in 1988, after the 22 years of death of Ambedkar, his writings started being published. And today there are so many publications are there, and all his works are available in different languages. And I feel that the fundamental issue, that the morality that he talks about is just not the social morality, it's the constitutional morality, with which reverentially we look towards the Constitution. And the vision that he talks about is the vision which always we take. In fact, last month, the Karnataka government passed a new law. I don't know whether you have read the law. It's in the teeth of the so-called love jihad, or the honor killing, of caste killing. Every state is also tying with the idea. Even Tamil Nadu government has appointed a High Court Judge Committee, but the Karnataka passed a law. In the discussion of the bill was done in Belgavi. I was invited by the Home Minister of, but the bill was finally passed. The bill was passed. For the first time, the Karnataka legislature says a man and a woman have a right to get married, and it is a constitutional right. So far, people thought it's only based on some religious. For the first time, the Karnataka High Court declared that it is a constitutional right of two individuals to get married, and thereby putting a stop to the so-called arguments of love jihad. And more important was, for the honor killing, there is a separate, that law provides for a separate legislation. Nowadays, we don't refer to laws by the name of the offense or name of the offense. They are also giving a name to the law. The name of the law is Iva Namava. Iva Namava. You know, I did not translate Iva Namava bill. Everybody is wondering what is Iva Namava. Where does they get this Iva Namava? In 16th century, there was a ruler by name Basava, and he has made so many ethical codes which are written in the form called Vachana. So the Vachana is only a structural statement of Basava. The Basava made a Vachana, which is very important. The bill name was from this Vachana. Iva Yarava, Iva Yarava, Iva Yarava, Ennadiriya, Iva Nammava, Iva Nammava, Iva Nammava Endu Helayya. So they said Iva Nammava means he is our man. When Prime Minister goes all over, says Vasudeva Kudumbaga, the whole world is one world. But then this person will be kept away. And to remove that, the Karnataka government says Iva Nammava bill. Now that's a very standing monument where the constitutional morality has taken to a higher level. And in that level, I think we should continue to work and remember Ambedkar forever. And in this 136th year of his birthday, it's very apt for this institute to start a lecture in his name. Thank you. And I want you to read my paper more carefully. And I've also given references. You should read those references. And if you have any questions, you can write the questions and send it to me, because I can't hear very clearly. If you write any questions, I'm willing to answer those questions. Thank you.
Sir, at the outset, I would like to place on record our sincere gratitude to Justice K. Chandru for an illuminating and deeply engaging lecture. Sir, your insightful exposition of constitutional morality and the vision of Dr. B.R. Ambedkar has enriched our understanding of the foundational values that must guide our institution and public life. You have reminded us that constitutional morality is not merely a principle to be observed, but a practice to be lived and upheld in our everyday governance. The way you connected Dr. Ambedkar's vision to contemporary challenges has been particularly thought-provoking and relevant, especially in the context of strengthening democratic institutions at the grassroots level. On behalf of KILA, I extend our heartfelt thanks for your valuable time, profound insights, and your inspiring address. We deeply appreciate your contribution to this Ambedkar lecture and look forward to your continued engagement in the series to come, sir. So, we are very thankful to Justice K. Chandru. I will just add one more thing to this particular session because I purposefully left out one mention in my presidential address. That is with regard to Sri V. Sudeshan, who is the director of Kerala Institute of Local Administration, this particular center. He has been the man behind this particular chair right from the beginning, which I have told from August 2024 onwards. He has been actually pressurizing me. Yes, he has actually forcing me to do this particular thing because I have taken this matter to the government several times, but every time it was not been fully accepted. But because of his enthusiasm and also his team at KILA, who has been working as a good team for the last 2 years, and the result has come out. So I personally and on behalf of Director General KILA thank Sri V. Sudeshan and his team at KILA, CHRD, for their continuous effort for bringing up this particular chair here, and we all need to take this forward. So I personally thank you, Sri Sudeshan, for this particular thing. He has been very, I don't want to use other words because he is the good person behind this. And also, as I would mention in the beginning, before going to tea, I want to just remind you once again, you should take the deliberations given by Justice K. Chandru. See how inspiring he has given you a lecture, touching to the different articles of the Constitution, emphasizing the need of constitutional morality, and also Dr. B.R. Ambedkar's vision. So you are the person who have to take this forward, and definitely your effort will give result for his inspiring speech, and that should be the word which we can give to Justice K. Chandru also. And I assure you on behalf of KILA, sir, we will take this forward, and your lecture will definitely be a laying stone for this particular thing. Thank you very much.
Okay, thank you, sir. And we are having a short tea break. Please adhere to time. We can have 10 minutes. Yeah. And by the time, no, questions can also be put forward. It can be placed here or can be given to me. Okay. And one more announcement is there. See, we are having washroom facilities in both the floors. Okay. In the lower floor, we are having more number of washrooms.
Okay. Okay.
ക്വസ്റ്റ്യൻസ് തയ്യാറാക്കിയിട്ടുള്ളവരൊന്ന് തരണേ ഫോർ ഡിസ്കഷൻ. ഒരു കാര്യം, ഒരു QR കോഡ് വരുന്നുണ്ട്. അത് എല്ലാവരും ഒന്ന് സ്കാൻ ചെയ്തിട്ട് ഗ്രൂപ്പിനകത്ത് ആഡ് ആവാൻ വേണ്ടിയിട്ടുള്ളതാണ്. സോ സ്കാൻ ചെയ്തിട്ട് ഇത് പാസ് ചെയ്തോളൂ. So we can now move to first technical session on gender perspective of Ambedkar thought. So we are privileged to have a distinguished panel of speakers with us today. It's my great pleasure to introduce our first speaker and chair of this session, Dr. Malavika Binni, Assistant Professor at Kannur University. She is a distinguished historian, writer, and academician whose work spans Dalit histories, history of science and religion, and folklore studies. Beyond academia, she is also actively engaged in historical texts, directing plays, and curating cultural programs, reflecting her diverse intellectual and creative contributions. We are truly privileged to have such an accomplished and dynamic personality with us today. Ma'am, I extend a warm and heartfelt welcome.
Thank you.
Ma'am, am I audible?
Yes, I can hear you clearly. Can you hear me?
Okay, thank you, ma'am. Once more, heartfelt welcome.
Thank you so much.
Next, we warmly welcome Dr. Sabu Thomas, Professor of Political Science at Government Brennan College, Talassery, and former coordinator of the Dr. B.R. Ambedkar Chair at the University of Calicut. He is also an active member of various professional bodies such as International Political Science Association, Montreal, Canada, American Political Association, South Asian Network for Public Administration. These are the, to name few organizations. His rich academic experience and contributions to social thought
greatly enrich this session. Sir, we extend a warm welcome to you for this. Sir, a warm welcome. Okay, thank you. Now I invite our speaker, Dr. Malavika Bini, to begin the proceedings. Ma'am.
Thank you so much. I hope I'm audible and it's clear.
Yes, ma'am.
Thank you so much. Distinguished guests, faculty members, research scholars, students, and all who believe in social justice. Jai Bhim. Let me put on record at the very outset my immense thanks to KILA Kottarakkara, particularly the director of KILA Kottarakkara, Sri V. Sudeshan, for persistently calling me for its inaugural program as well as this program. And let me also put on record my deepest apologies that I am not able to be there in person. I had a death in the family and then I had a fall and I have been put on lumbar support now. So I've been asked not to travel. Otherwise, I would have definitely been there, particularly since the institute itself is in Dr. B.R. Ambedkar's name. Let me also thank the Director General of KILA, Sri Nizamuddin, for his efforts and the entire team for bringing together such an initiative as well as such a extremely erudite panel of scholars and activists and Ambedkarites together. Today, as I'm here to speak about the gender perspective of Dr. B.R. Ambedkar, we all know that I'm here to speak about a man who gave India its constitution, who fought caste with the fury of a wounded civilization, and who, in the midst of battling untouchability, who, in the midst of battling gross social injustice, found time to wage another war, the war for women's liberation. And the subject of his fight, which was against all forms of inequality, is nothing but extraordinary. And often within feminist academics and feminist historiographies, particularly South Asian feminist historiographies and women's studies, his perspectives on gender rights is largely overlooked. In his 1941 speech at the Bombay Presidency Women's Conference, Ambedkar said, I am not a woman, but I can feel for them. I have seen the suffering of my own mother, my sisters. The only way to destroy caste is to destroy the subordination of women. When we remember Dr. Ambedkar, we remember certain images. We see the chairman of the drafting committee, the law minister, the economist, the scholar who converted to Buddhism, the historian. We remember his fight against caste. We chant his slogans, educate, agitate, and organize. We quote his line, I was born a Hindu, but I will not die a Hindu. But there is another Ambedkar we have collectively forgotten. The Ambedkar who said, and I quote, I measure the progress of a community by the degree of progress its women have achieved. The Ambedkar who drafted the most radical gender just legislation the world has ever seen in mid 20th century. The Ambedkar who resigned from the cabinet of Jawaharlal Nehru, resigned from power, resigned from his position, and maybe even his legacy, not over caste, not over Kashmir, not over language policy, but over a bill that sought to give Hindu women, that sought to give Hindu women the right to divorce, the right to inherit property, the right to be free from lifelong widowhood, the right for equal rights with men. Quite often, when political leaders are questioned on women's rights, they resort to anecdotes and often very nostalgic anecdotes or stories about their mothers in particular. And in these stories and in these anecdotes, they usually tend to glorify motherhood, how their mothers would have taken care of them, how their mothers would have fed them, how their mothers were strong, so on and so forth. But you would never hear a word about patriarchal oppression that their mothers faced, about the kind of cruel systems of repressions that are extant in Indian families. But when Ambedkar talked about his own mother, he said, I have seen my mother beaten by my father. I have seen my sisters widowed as children. I have seen women of my own community carrying night soil on their heads, even while their men watched. Women being beaten by their husbands, women doing domestic chores was commonplace in almost all communities for the period. But Ambedkar understood this as structural oppression and did not even remove his father from critique. This was both equality and compassion at work in Ambedkar. But let us not reduce his feminism to mere biography. Ambedkar was a trained economist and jurist. He had read from Dewey, John Stuart Mill, Mary Wollstonecraft, and the socialist feminist of Europe. Of course, Ambedkar was greatly influenced by two core philosophies in his life, one being pragmatic progressivism and the second being Fabian socialism. And all through his writings, you can see the influence of both these philosophies, and even on his perspectives on women's rights, you do see the impact of these core philosophies. Though Ambedkar had read most of the Enlightenment thinkers of Europe, socialists in particular, he had more importantly read another work, and that work was called Manusmriti. And he had seen how Manu's laws uh, impacted women. He understood that Manu's laws were not just religious verses, they were operating manuals for caste and gender terrorism. Ambedkar's central insight, and this is crucial, was that caste and patriarchy are not separate systems. They are the same system with interlocking axes of oppression woven into one another. Long before Uma Chakravarti's argument on double disadvantage, or Kimberly Crenshaw's concept of intersectionality, or Patricia Hill Collins' standpoint epistemology, Ambedkar spoke about the entwining of caste and patriarchy, very precisely identifying that the subordination of women was the bedrock of caste. In his 1916 paper, Caste in India, the Mechanism, Genesis, and Development, Ambedkar made a startling argument for that time. The argument was that caste is not about purity, and caste is not about purity and pollution alone. At its heart, caste is about endogamy, marrying within one's group. And endogamy, he said, is a negation of the idea of a common nationality. And I quote again, because he is using the term nationality very precisely and very consciously here. So he says, endogamy is a negation of the idea of common nationality, a point that he reiterates in his magnum opus Annihilation of Caste in 1936 again. But how do you enforce endogamy? Now, this is a central question that you see throughout his works. You see these, you see this in Who Were the Shudras, you see this in Who Are the Untouchables, you see this in Annihilation of Caste, you see this in several of his speeches from 1936 to 1940. This is one of his central questions about how an endogamy is enforced in India. How do you ensure that every daughter marries within her caste? Every son does not bring home a woman from a lower caste. You cannot use police forces for marriage. The, there is very little scope for a complete control over human sexuality. So you use something far more effective. You control women's bodies, their sexuality, their mobility, their choices. Long before Foucault theorized on the panopticonization of and power and discourse, and long before Noam Chomsky argued on the manufacture of consent by subject populations, Ambedkar talked about how religious ideology and ritual power was used to control women's bodies to enforce and maintain caste endogamy. Before Ambedkar, you had dozens of Western scholars and a handful of Indian scholars who wrote about sati, who wrote about child marriage. Scholars like Marx and scholars like Mills would use it to refer to the static and unchanging nature of Indian society. They identified it as inhuman and cruel, but it was Ambedkar who delinked the practice of sati, who delinked the practice of child marriage from wifely duty and religious dharma, and pegged it to that of caste, particularly to that of caste endogamy. Sati, the burning of widows, was not, he argued that Sati, the burning of widows, was not about devotion. It was about preventing a widow from remarrying outside the caste. Child marriage was not about tradition. It was about ensuring a girl's sexuality was locked into the right caste before she could develop any of her own will or thought or exercise her own agency. Widow celibacy, the shaving of their heads, the removal of bangles, the wearing of white saris, the social death of a woman, in other words, whose husband died, was not at all about spirituality. It was about property and purity. A widow might inherit and she might choose a man from another caste, and this had to be prevented at all cost. So her social death or her actual death had to be ensured. In his theorization about surplus women, he elaborates this. One of Dr. B.R. Ambedkar's most original and penetrating insults into the functioning of the caste system lies in his concept of surplus men and women. And for our young friends in the audience who might not have read Ambedkar yet, let me elaborate. So, in his 1916 paper, Caste in India, Their Mechanism, Genesis and Development, Ambedkar explains how the seemingly disparate practices of sati, child marriage and enforced widowhood are not isolated customs but interconnected mechanisms designed to solve a single problem: maintaining numerical parity between marriageable men and women within, or men and women of a fertile age within a closed endogamous caste group. Ambedkar argued that the single most distinctive feature of caste is endogamy, the rule that one must marry within one's own caste. Unlike class systems, which are open and allow considerable social mobility through marriage, caste is closed or enclosed class that forbids any kind of mobility. As Ambedkar wrote, caste in India means an artificial chopping off of the population into fixed, definite units, each one prevented from fusing into another through the custom of endogamy, enforced through ritual power. Here is Ambedkar's crucial insight. Endogamy is mathematically impossible to maintain perfectly over time in nature without strict controls over human life and death. Why? Because in any closed group, births and deaths do not occur in perfect male female pairs. People die at different times. In any caste, more boys might be born. In any some other caste, more girls might be born. There might be war, which means that more able-bodied men might go to war, and there might be a paucity of men of the fertile age or marriageable age in a group. More women might die in a group because of maternal mortality rates. So in any given group, there will never be a situation where there are equal number of marriageable men and equal number of marriageable women. The natural result of this situation would be a constant fluctuation in the ratio of marriageable men and marriageable women, which will usually force the members of that group to go looking for life partners in another group. Ambedkar wrote, left to nature, the much needed parity between the units can be realized only when a couple dies simultaneously. But this is a rare contingency. In other words, nature does not automatically maintain the one man, one woman ratio that endogamy requires. When a caste group experiences a surplus of women or a surplus of man, a dangerous possibility emerges. These extra individuals, unable to find a life partner or spouse within their own caste, might tend to marry outside the caste. Such an act would break endogamy and in Ambedkar's framework would be the beginning of the end of caste itself. In other words, this would lead to the annihilation of caste. As he stated, if endogamy is to be preserved, conjugal rights from within have to be provided for. Otherwise, members of the group will be driven out of the circle to take care of themselves in any which way they can. Therefore, every caste group must develop mechanisms to quote unquote dispose of surplus men and surplus women so that they do not become threats to caste purity. Ambedkar observed that caste society solved this problem of surplus men or surplus women in two dramatically different ways, depending on whether the surplus individual was male or whether the surplus individual was female. And in this explanation that he gives of surplus men and surplus women, you can see the crucial kind of understanding that Ambedkar had of Indian women and Indian men and the patriarchal structure of Indian society and culture in general. So, caste society, according to Ambedkar, gives two solutions when you have surplus men. That is, in a caste, if you have more men than women, there are two possible solutions that caste society throws up. Solution number one was sati, or burning of the widow. The most extreme solution to eliminate surplus women entirely by burning her on her husband's funeral pyre. Ambedkar identified sati not as an act of pativritya or devotion or spiritual merit, but as a coldly functional mechanism for removing a demographic problem. The widow's death restores numerical balance within the caste, and her physical elimination guarantees that she cannot marry outside, which further guarantees that wealth or property or inheritance rights do not move from one caste to the other, so thus cutting away all possibilities of mobility or caste transgressions. For example, imagine that an upper caste Rajput widow is living in the 18th century, let's say Rajasthan or Kerala, wherever. Her husband, the only suitable match for her from her particular caste and her subcaste, has died. There is no widower of equivalent status usually available. Rather than allow her to remarry into a different subcaste or marry outside the caste, she would have been pressured or forced to ascend her husband's funeral pyre. Thus, sati would eliminate or solve the problem of uh, surplus, the surplus woman at hand. Hello, can you hear me? Hello, is there a power outage problem? Can you hear
Yes,
me?
ma'am.
Should I wait or shall I continue? What should I do?
Yes, ma'am. Continue, ma'am. We can.
Okay, sure. The second solution was enforced widowhood. So the first solution was sati, burning the woman on the funeral pyre of her husband and completely eliminating any possibility of her straying outside the caste. The second possibility was social death, reduce or trivialize the woman's life into that of a corpse or a social corpse in this case. So when sati was not possible or practical, like in the case of colonial prohibition over sati, caste society developed another alternative, the living death or the social death or enforced widowhood, where the woman's head would be shaved. She could only wear plain or very colorless sarees, no jewelry, no color, no ornaments were allowed. She would have to sleep on the floor. She would have to eat only one meal a day, and she would have to eat very bland meals. There was a complete prohibition on any kind of presence during an auspicious occasion like marriage or childbirth or any kind of good functions in the family. Confinement to the domestic sphere, often to a single room or to an ashram where you would have fellow widows. Exclusion from any kind of social, even particularly religious rituals, so on and so forth. So the surplus woman in this case, unlike the case of the surplus man, is rendered sexually and socially inert. So surplus woman might not be killed. The other resolution would be the social death of the woman. So two choices that the caste society offered in the case of surplus men and women would be either A, sati, or two, the social death of women. Now, let us assume that there are more or surplus men in a given society. A surplus man arises when a wife dies before her husband, or in the case where there are more uh, more women in society than men. Sorry, so more men in society than women. Now, how does caste society respond to this? Ambedkar says the response is radically different. Ambedkar observed that, and I'm quoting, being patriarchal, the caste system did not allow a surplus man or a widower to be the subject of the same treatment as that of a woman, because losing a man for that particular society was depletion in group numbers, because a group's strength depended on the number of male members. A man is an economic asset, a protector, a continuation of the lineage. Caste cannot afford to burn or socially kill its men. So, what was the solution? The surplus man is allowed, even encouraged to remarry. But where will a new bride come from, particularly from the same caste, if all the women of appropriate marriageable age within the caste were already married? The solution for caste Hindu society was simple: marry a girl who has not yet reached marriageable age. This, according to Ambedkar, is the origin of child marriage. By taking a prepubescent bride, the widower obtains a bride who will become marriageable in a few years. In the meantime, she is absorbed into his household. The numerical surplus is resolved, and endogamy is safe, intact, and preserved. However, this creates a new problem: competition for brides. If many widowers remarry, they consume brides who would otherwise be reserved for young, never married men. To address this, caste society permitted another practice: hypergamy, allowing men to marry women from slightly lower subcaste or ranks. This downward marriage, quote unquote, downward marriage for men, which was strictly forbidden for women, provided additional marriage options for surplus men. Now, if you take Kerala's case, for instance, the case of Sambandham, which is practiced by Nair caste, can very easily be explained through Ambedkar's theory of surplus men and surplus women, or the marriage of Nambudiri men, the firstborn Nambudiri men to women of Nair household can also be explained by the use of Ambedkar's surplus men and surplus women theory. Now, Ambedkar's surplus men and women theory is not a narrow demographic argument, nor is it a narrow sociological argument. It has profound implications for understanding the patriarchal structure of Indian society. First, it shows that caste and gender oppression are not separate systems, they are the same system. The practice that most brutally subordinates women, whether it was sati, whether it is marriage, whether it is widow degradation, or in the present case, whether it is dowry, exists because caste needs to control women's bodies to maintain itself. As the famous feminist scholar Sharmila Rige puts it, women are the gateways of the caste system. Second, the theory explains why social reformers who focused only on abolishing sati or promoting widow remarriage. We all have the celebrated social reformer Raja Ram Mohan Roy. I have nothing against him other than the fact that he did not understand that endogamy and caste were the root cause of sati. So, without attacking caste, any kind of gender oppression that was present either in pre-independent India or present in present day India, and reformers who seek to address issues of quote unquote women empowerment or gender inequality without addressing caste are solely missing the point. Sati or widow remarriage or a dowry is but a symptom. The disease is endogamy. As long as caste exists, new mechanisms of controlling women's sexuality and marriage will emerge. Now, let us take the case of dowry. Why do we have such exorbitant rates of dowry, even in a state like Kerala? Because the number of marriageable men or suitable boys, as we refer to them, in a given caste are very, very small compared to the number of women, because we have more women to men in Kerala, thanks to a very gender positive ratio. And because caste exists, the dowry would keep on increasing because the number of marriageable men as compared to the number of women are very low, or the number of appropriate young men as compared to the number of young women within the fertility bracket are low. And because one has to marry within the caste itself. If you look beyond the caste, you would probably find an appropriate life partner for yourself or for your daughter, but you're only looking within the caste. And because you're only looking for a prospective bridegroom within the caste, what would happen? You would have to give a exorbitant or a very high amount of dowry, and the amount of dowry, or whether we call it dowry or gift or whatever, or share or whatever you want to call it, if it is not transferred to you, the daughter, that means that it is dowry, no matter what name you might call it by. So, then these rates of dowry will continue to increase, because Ambedkar has so beautifully explained it in his theory of surplus men and women. It's just that we don't eliminate our women, no, we try to surveil them and subordinate them through other mechanisms and means. Thirdly, This particular theory reveals the deep material basis of what appears to be tradition or religion. Sati is not a spiritual practice. It is not about devotion to one's husband. Similarly, a lot of the rites and rituals that go under or slip under the traditions of marriage, whether it is the practice of wearing sindoor or whether it is the practice of wearing a mangal sutra or a tali, all of this uh, all of this uh, is not just demographic management, but it has a deeply material basis which reinforces patriarchal control over women's sexuality as well as women's bodies. Quite usually, these are ritual techniques dressed in religious clothing. And Ambedkar does not mince any words when it comes to either parda or ghungat or the other kind of sat shringar, which is associated with signs of marriage. Fourth, the theory explains why Ambedkar placed such emphasis on women's economic independence and legal rights, something that he fought for all throughout his life. The surplus problem is solved only when women have no alternatives. A woman with property, with education, with legal recourse cannot be easily disposed of. This is why the Hindu Code Bill's provisions on inheritance, divorce, and maintenance put in place by Ambedkar was so threatening to caste orthodoxy. Ambedkar's theory, written all the way back in 1916, it has been more than a century since he has produced this theory, and it's till date it remains startlingly relevant. Now, in India, where we have dowry and female infanticide, where we unfortunately have honor killings, and you should not think that honor killings are limited to North India. We have had two honor killings in the past decade in Kerala. We had one in Teen Kurishi a couple of years ago, and and all of us know about Kevin's case. So it is not something which happens in far off North India. It is also a reality that Keralites are facing till date. Murders of couples who marry outside their caste, or social ostracism of couples who marry outside their caste or religion, can also be explained by the surplus theory. The surplus created by a daughter's desire to choose her own partner or a son's desire to explore for a partner beyond the community is quite often sold either through social death, which is a complete cutting away of the young couple from community and the life that they are used to, or through actual death. The persistence of caste-based marriage. Now, I looked at an Indian Express survey, which was from 2021, and found that 94% of marriages in India are still according to caste, and 91% of people in the age bracket of 35 to 65 still believe that arranged marriages are the best form of marriages. You still have matrimonial websites which are organized according to caste and who shamelessly give advertisements on national mainstream televisions about how good they are at finding partners for daughters and sons from their own caste. Families still disown children who marry not within caste lines. These demographic mechanisms today might be less violent, particularly in a state like Kerala. But the underlying logic of caste endogamy, of limiting young people's sexuality, of controlling women's bodies, this logic, this Brahmanical patriarchal logic, which Ambedkar challenged, unfortunately still remains, and we need to acknowledge it. Ambedkar's concept of surplus men and women is one of the most brilliant and underappreciated contributions to feminist theory. It demonstrates with absolute precise demographic logic why the caste system necessarily produces violence against women: physical violence, epistemic violence, and cultural violence. It shows that these sati or child marriage or other kinds of marriage based practices are not ancient traditions to be respected, but brutal technologies of population control. And it reveals the fundamental truth that you cannot destroy caste without liberating women, and you cannot liberate women without destroying caste. Ambedkar wrote, the system of caste is based and absolutely based on the law of endogamy. The virtue of a woman is the most important asset of a caste. So the virtue of woman, and I say the virtue of a woman is not her most important quality. Do remember that it is a function of caste. Let that sink in. In other words, a woman's virtue is not her own. It is nothing to be proud about. It is a property of her caste. Your sister's body is a boundary wall. Your mother's pativritya is a caste ceiling. Your wife's fidelity or your partner's fidelity is a national security issue for the caste nation. That is why Ambedkar said that you cannot destroy caste without destroying endogamy. Now, when we come to the centerpiece of Ambedkar's gender legacy, rather, one cannot even refer to it as Ambedkar's legacy. One can refer to it as his legacy only in the realm of philosophy because it didn't come to be. If the Hindu Code Bill was passed, it might have been his most impactful legacy and one of the most revolutionary moves for the liberation of South Asian women. Most Indians have not even heard of it. They have not looked at the debates regarding it. Most historians, even gender historians, refer to it in passing or as a footnote. But I will argue that the Hindu Code Bill, as drafted by Ambedkar, is the most revolutionary piece of gender legislation ever proposed in the global south. And its defeat is one of the greatest betrayals of Indian women. Let me give you the context. In 1947, India became independent. Hindu personal law, the law governing marriage, divorce, inheritance, adoption, and guardianship for Hindus, was a patchwork at that point of time of medieval text. Why? Because the British, when they made law for the Indians, depended on Brahmanic courts of justice, like the Manusmriti, like the Yajnavalkya Smriti, like the Brahman Smriti, and they thought of Brahmins as the experts of law. So, what was understood as Hindu law was Brahmanic law. According to this, a Hindu woman could not inherit property. A Hindu woman could not divorce her husband, no matter how cruel or how infidel he was. A Hindu widow lost all rights to her husband's property. A Hindu man could marry multiple wives. A Hindu woman had no right to adopt a child. A Hindu daughter was a temporary resident in her father's home. Ambedkar, as the first law minister of India, decided to change all of this in one sweeping piece of legislation. The Hindu Code Bill, introduced in 1951, it contained the following provisions. 1. Monogamy for Hindu men. No more second wives when the first is alive. 2. Divorce for women. A woman could seek divorce on grounds of cruelty, on grounds of desertion, adultery, or disease, or if she discovered that her husband had another wife. 3. Equal inheritance. A daughter would get an equal share in her father's ancestral property alongside her brother. 4. A widow would inherit her husband's property fully, not as a regent, not as a guardian or a life estate, but as an absolute honor. 5. A woman, unmarried, widowed, divorced, could adopt a child. 6. A woman would be entitled to maintenance even if she lived separately, if the husband was cruel or adulterous. These provisions were not incremental reforms. It was one broad, sweeping strike at Brahmanical patriarchy. This was a revolution, a legislative revolution. They were an assault on 4,000 years of patriarchy. What happened next, unfortunately, is a very shameful chapter in Indian political and legal history. Conservative members of the parliament, many of them were freedom fighters. They could understand freedom from the British, but they could not understand freedom from patriarchy. Many of them, Gandhi's disciples, rose in fury. They said that the bill would destroy the Hindu family. They said, a lot of these arguments by patriarchal men and conservative men, they have remained the same for centuries. Now, the claims that they made against the Hindu Code Bill and the provisions instituted by Ambedkar are the same arguments that misogynist men and patriarchal men make today against most progressive legislation. They said it was Western, they said it was immoral, they said it was anti national, they said it was anti religious, they said it was anti family. One member said that giving property to daughter would make them uncontrollable. Another said that divorce would turn Hindu women into sex workers. President Rajendra Prasad, the first president of India, openly threatened to veto the bill. Prime Minister Jawaharlal Nehru, who claimed to be a socialist and modernist, remained rather ambivalent and spoke very little about the bill. He did not want to offend the conservative sections within the parliament. Ambedkar alone, and Ambedkar fought alone in the parliament with feminist organizations supporting from the outside. In a magnificent speech in the parliament, he said, I am surprised that the opposition should come from the so called educated men. They say the bill is revolutionary. Yes, it is revolutionary. It is revolutionary because it seeks to put women on a footing of equality. And if that is a revolution, I am proud to be a revolutionary. But unfortunately, Ambedkar lost. The bill was stalled. In September 1951, Ambedkar resigned from the cabinet. Rather, Ambedkar had to resign from the cabinet. Let me repeat that. He resigned from the highest office in the land because he would not compromise on women's rights, because he would not compromise on gender equality. He could have passed a diluted bill, but he kept his position. He chose integrity over power. After his death in 1956, the bill was broken into 4 parts and passed as the Hindu Marriage Act, the Hindu Succession Act, the Hindu Adoption and Maintenance Act, and the Hindu Minority and Guardianship Acts. But these were very weak and diluted versions. Ambedkar once said, now, his position of resigning over the bill. This is a model which was against his core philosophy of pragmatic progressivism, where usually Ambedkar would compromise on certain things so that legislation could be made to protect the rights that he was fighting for. But this was one kind of right, because this was based on the absolute idea of equality that he was fighting for. So this, he was not ready to dilute it. He was not ready to take a weakened bill. He was not ready to compromise on it. So Ambedkar goes against the other kinds of maybe decisions that he has taken in his life, and resigns from the position of law minister for women's rights. And this choice of Ambedkar of integrity over power, this is a great role model for us to follow. And particularly for the younger friends in our audience, this is something that we ought to remember. Tomorrow, when we engage in our fights for social justice, in our personal lives or in our public lives, I don't think there is much of a distinction between the two, particularly from a feminist perspective. The choice of integrity over power is something that we need to hold steadfast to. Ambedkar once said, law is the instrument of social change, but law without economic power is a paper sword. He also argued that Hindu courts bill inheritance provisions were not just about property, they were about bargaining power. A woman who inherits land can say no to a violent husband. A daughter who knows she will get her father's house as inheritance can refuse a bad marriage. A widow who owns her husband's property cannot be thrown out. But alas, after Ambedkar's death in 1956, the bill was broken into 4 parts and a greatly diluted version of the bill was passed. The equal inheritance for daughters was removed from this, and it took years up until 2005 to restore it. The right of a daughter to be a co-parcener in joint family property, that only came in 2005, almost 50 years after Ambedkar's death. Or in other words, Ambedkar was half a century ahead of his time, and Indian politics, unfortunately, punished him for it. Let me also include in this lecture how Ambedkar used history to wage a war against patriarchy, because as a historian, I do feel that it is my responsibility to talk about Ambedkar's use. Today we hear about misuse and the distortion of history. But here we have in Ambedkar a historian who used history for social justice. In The Rise and Fall of Hindu Women, written as part of Who Were the Shudras, Ambedkar made a stunning claim. He said that in the Vedic period, the earliest layer of Hindu culture, women were not subordinate. They studied the Vedas, they participated in public rituals, they attended philosophical assemblies. Women like Gargi and Maitreyi debated with men. The Rig Veda, for instance, have several verses composed by women. So what happened? Ambedkar's answer, the Brahmanical counter-revolution. With the composition of Manusmriti around 2nd century BCE to 2nd century CE, women were systematically reduced to the status of Shudras. They were denied education, denied property, and denied ritual rights. They were made perpetual minors, almost under the guardianship of a man. Ambedkar wrote, the Hindu woman's virtue has been her misfortune, because her chastity was required not for her own dignity, but for the preservation of caste. The historical argument is crucial because it destroys the myth that patriarchy is natural, that it is culture. Ambedkar shows that patriarchy, at least in the case of Hindu culture, was invented, imposed, and enforced by a priestly class for its own power. And if it was invented, it can be dismantled. Now, I'll finish in another 10 minutes talking about uh, Ambedkar's fight for women's rights when he was part of the Viceroy's Executive Council and the Bombay Legislative Council, because quite often people philosophize, they tend to write very eloquently and speak very eloquently about women's rights, but when they're put in positions of power, they don't move a finger for women's liberation. But in the case of Ambedkar, as soon as he was given a position in the Bombay's Legislative Council or as part of the Viceroy's Executive Council, he would advocate for women's rights. So, for instance, while he was in the Executive Council of the Viceroy from 1942 to 1946, he would champion a very comprehensive agenda for women's workers, for equal pay for equal work, restoration of the ban on women working underground in mines. He would institute a women's labor welfare fund, leave benefits, including maternity leave benefits for peace or part-time workers. Ambedkar was not merely reacting to problems, he was building a system. He understood that labor laws, social security, and gender justice were inseparable. Now, you would also see, while I was going through these records, you would even see Ambedkar advocating for birth control rights. And when he is talking about birth control rights, he is addressing women, because he says that if men had to bear the pangs of what women undergo during childbirth, none of them would ever consent to bear more than a single child in his life. And then he goes on to say that birth control must be made available to women. So what connects Ambedkar's maternity leave advocacy with his birth control advocacy? A consistent philosophy. Women's reproductive lives must be respected and protected. Maternity leave protects the women who choose to bear children. Birth control protects the woman who chooses not to. Both are faces of the same coin, according to Ambedkar, that of reproductive justice. For the lack of time, I am quickly wrapping up and moving to the last section of my address. There was also one section on Buddhism and women, and how Ambedkar, when he is instituting a new social order within Buddhism called Navayana, quite often referred to as Bhimeyana, how a lot of his reforms that he made in Navayana were largely female-centric. So skipping that and maybe reserving that for a future lecture, let us now look at what is the contemporary relevance of Ambedkar, not just for feminism, but for any fight on equality. 6 points. First, because the Hindu Courts Bill agenda is still unfinished. Even today, women do not have equal rights in all matters of succession. Many families still use wills to disinherit daughters. Because the debate over uniform civil code has returned with ferocity. And please listen to this, Ambedkar's nuanced position support uniform civil code, but only if it is progressive, consensual, and protects minority rights. Now, this position that is taken by Ambedkar on UCC has been completely lost. One side wants no UCC, the other side wants a majoritarian UCC. Ambedkar's middle path, based on protection of minority rights, based on consensuality, the feminist path remains unexplored. Third, the farmers' movements, the Me Too movement, the cure movement for LGBTQ careers, all of these are Ambedkarite struggles. He understood that violence against women, violence against vulnerable communities, violence against marginalized is not a private matter. It is a public crime and the state must intervene. Four, because intersectional feminism that dominates global academia today. The idea that gender, caste, and class cannot be separated. This was used by Ambedkar over a century ago. Five, because Ambedkar gives us a way to talk about religion and women's rights without being either relativist or bigoted. He did not say that all religions are equally bad for women. He compared them. He criticized Brahmanical patriarchy without excusing other kinds of patriarchy. He praised Buddhist equality without denying Buddhist failures. This is the mature scholarly political feminism that we need today. Six, we still debate over maternity leave. We still debate over menstrual leave. If you take a page from Ambedkar's book, you would see that Ambedkar would constantly advocate for women's health, constantly advocate for removing the surveillance over women's bodies. Why? Because it contributes to national health, because it contributes to national development and national growth. So finally, when you're looking at Ambedkar and when he says, I measure the progress of a community by the degree of progress which women have achieved. If we apply that measure to India today, how, or Kerala today, how do we fare? We have laws on paper. We have equal pay on paper. We have inheritance rights on paper. But the gap between law and reality remains vast. Ambedkar did not merely leave us laws. He left us a method: educate, agitate, and organize. He left us a vision: women as producers, not ornaments, not as sex objects, women as decision makers, as agents, not as dependents, women as equal citizens, not property. Ambedkar was not a feminist because it was fashionable. He was not a feminist because he wanted to please Western daughters. He was a feminist because he believed in equality for all, and his idea of democracy was inclusive. The revolution he began has not finished. Every time a woman inherits her father's house, that is Ambedkar for you. Every time a woman divorces a violent, abusive husband, that is Ambedkar for you. Every time a Dalit woman like me stands up for justice and says, I am not just a Dalit, I am a Dalit woman, you will have to hear me. That is Ambedkar. So let us not reduce him to a statue. Let us not reduce him to a slogan. Let us pick up his unfinished work. Let us build a where no woman's body is a boundary, no woman's virtue is a caste asset, where no woman's suffering is called tradition. So let us truly embrace the feminist revolution that Ambedkar has commenced for all of us. Thank you.
Okay, thank you, ma'am. I invite Dr. Sabir Thomas. Yeah. Sir, 10 minutes, sir. Yeah, we will have the response after this presentation. Okay. എല്ലാവരും ഗ്രൂപ്പിൽ ആഡപ്പ് ആയിട്ടുണ്ടല്ലോ. ആ ക്വസ്റ്റ്യൻസ് ഒന്ന് ആഡ് ചെയ്യണേ ഗ്രൂപ്പിൽ, നമ്മുടെ വാട്സപ്പ് ഗ്രൂപ്പിൽ. സ്കാൻ QR കോഡ്.
So, okay, very good afternoon. Now it's good afternoon. so thank you, the organizers, for giving me an opportunity to be here. And I'm very glad to associate with the Ambedkar chair because, see, I start with a very single statement. Why we are talking about Ambedkar? As far as I know, this is the fourth Ambedkar chair in the state, fifth Ambedkar chair in the state of Kerala. Four universities are now KILA as an Ambedkar chair. So when we have started an Ambedkar chair in our university, our honorable vice chancellor told us in the first meeting, he said that we have a lot of chairs here, but most of them are not chairs, they are beds, sleeping beds. So let us start a chair. Chair is something different. So we started with the chair, and we have Dr. Sukhdev Thorat as our chair professor. So I think that hope that KILA will go on with people like our honorable judge and other people who will be joining in the later time. So, well, I will be talking about, very quickly I will be going over to my concept, it's about justice. And when you talk about justice, it is not about, it is a far-structured concept, like we are not moving to Plato, we are leaving Plato, and it's not about the myth of metals. Other than that, it is about fairness in social competition, about disparity, about different principles, some roles. And again, why we are talking about injustice, Ambedkar, because every other day we are having injustice, and these are veiled injustice. So last time, Madam Malavika, when he was telling that Ambedkar was a feminist, she wrote a lot on Ambedkar. And if I am meeting Ambedkar right now, I have a straight question to ask him. He married a woman called Sharada Kabir in 1948. After marriage, her name was changed to Savida. If Ambedkar was here, I have that single question to ask him. And when Ambedkar converted to Buddhism, his name was not changed. So, there is this kind of unveiled, this veiled injustice is going all about. So we have to be aware about that. That's why Ambedkar is relevant. And again, it's about processes and principles. By which resources, opportunities, and privileges are distributed. It's not about resources. It's about privileges. It's about opportunities. Justice is more than that. It's a living principle, a continuous principle, whereby everyday life we are meeting with injustice. In courts, in colleges, in everywhere. It's not only the case with one person in a dental college or in a medical college, in every classroom, every household. Injustice is something roaming around. Oh my gosh, I think the language changed. So, the problem is that there is a font issue with this presentation. So I'll shift to my presentation. I'll just, okay, one minute, just a minute. I'll wind up in another 10 minutes, no problem. You just give me a warning before 2 minutes. Because teachers are like that. When they have got a mic, it will be very difficult. So, okay, this. So what I'm telling right now, just 1 minute. The problem is that we have this issue. Okay, it's about difference principle, fair position, and again where this is. Then again, when you talk about the caste system in India, what's caste system in India? We have 4 castes, maybe perpetuated by the Virat Purisha or the Manu tradition. A few years back when we are having a chat with Prashant Bhushan, when I was chair in the Ambedkar chair, he was coming to us and he was telling that in bar there is a joke. There are 5 castes in in our system. One is the Shudra, Vaishya, Kshatriya, Brahmin, then the judges. So there are 5 castes. Like that, there is a political tradition. Apart from the Manu tradition, we have created another class. So that is Brahmin, Kshatriya, Vaishya, Shudra, and woman. That's the last class. So this caste system is very strong everywhere. Not only this 4 caste system. It's in political circles everywhere. You come across this kind of things. I'm not trying to bring the general kind of issues. I don't know what will happen to the presentation. So it's about, gender is just about performativity. It's about reinforced by the repetition of gender roles, gender behavior, not necessarily by biology. like your textbooks, where you talk about equality, but equality is always missing. And there is something called the glass ceiling, whereby even though you are powerful, capable, there are certain ceilings. Okay. So, okay, I'm coming to some data. That's the point where So it's about the glass ceiling. Look into our parliament, women representation in our Lok Sabha. So we have these figures whereby 2004 to 2024, the parliament representation is like that. We have a normal 8 to 10% representation in parliament. See, when you look into the Constituent Assembly and the draft of the Constituent Assembly, there are 248 signatures in the draft. And how many of them come from women? Only 15. Only 15 people belonging to the other gender, they signed the Constituent Assembly. And then we talk about a preamble which talks about we the people of India. We talk about 14, 17, 16 articles, like that. So the problem is that this kind of things it is difficult to understand. And again, coming to, yes. So the problem is that it's about the number of MLAs and MPs. MPs and MLAs, very different political parties. So I'm not, since the PPT has an issue. The thing is that there is a larger variation starting from the BJP, Congress, then again CPM. It is about 8% to 10%. So the problem, where do you have the problem? So one minute, just because I have 10 minutes, I'm not presenting too much things. See, the thing is that if you look into the BJP circle, so 10.3% is the total number of women representatives. Congress, it is 9.5. If you take Trinamool, they are doing better, 18.1. TDP, 13.9. Then Samajwadi, 12.6. CPM, 10%. This is the percentage-wise distribution of representatives in a country where you have more than 50% of women. And let us come to the scenario, political scenario, where you look at the political parties. Our honorable judge was talking about the Vanida Madil, woman wall, that has been created by maybe a few years back on the Sabarimala issue. So that wall has to be created in front of some political party officers. Just look into the pattern of political party officers. How many women presidents? How many women general secretaries? Apart from a token representation like women vice president. So the problem is that this political circle is not accommodating people. So why it happens so? Because there is some kind of glass ceiling. And who created this glass ceiling? It is being created not by nature, not by society. It is something that is being created by the political circle, because those who are in power, they can decide what kind of policies. You just look into the women reservation bill. The problem is that the slide is not moving. There's some font issues. So it's okay. I'm just winding up. So just look into the women reservation issue. Okay, I agree that there are political issues. Let us go back to if I remember rightly, 1994, the Uniform Civil Code verdict. When the Uniform Civil Code verdict was there was an attempt to bypass this by the then government. And it was easily bypassed because of some lame excuses. So the problem is that when you have a women reservation bill, everybody is against that. Maybe there are different kind of arguments, different kind of issues. But the core issue is that, what is your alternative? Okay, the present government is telling that we are going to increase the number of seats. Okay, it's wrong. It is not right. Then what is your alternative? Are you going to leave your seats for women? In Kerala we have 20 seats, 50% to women, 33% to women. Then whose seats will be lost? The problem is that it is being structured. There is some kind of inhibition that is being created by, I think that's one of the phone, this is a phone issue. It won't work. Okay, I'm leaving. I'm just my core point here is that what we have to do is about transforming structure. I'm coming to the end of this presentation. What we can do is about transforming structure. How you can transform structure, that's an issue. First of all, you have to understand the structure, what it is, where it is wrong. It's not about writing about women, presenting a paper on women. More than that, understanding what is the issues hidden inside the society. The fourth caste, fifth caste. Then again, transforming the self. The self, that is an important thing. You cannot change the society in a fine day, in a fine morning. You cannot come and tell that everybody is equal. It can be done by a constitution. But in your real life, it is not possible. So, we can start transforming the self. Like maybe this performativity kind of things can be restricted. Then the other thing is about transforming politics. The third point is about transforming politics. That is the key point. Being a student of political science, being a practitioner of political science, I believe that 90% of the problems comes from politics. So do we have a gender audit? I am associated with the International Political Science Association, and I am a governing council member of RC10, one of the research committee. Every 2 years we are having a gender audit of our organization. How many members are women? How many of them present papers? Then I have a question. You look around our system. During our class 1 general, I asked to my students in the university. You have a big university, there's a vice chancellor, there's a controller of examination, there's a finance officer, there's a registrar. 5 statutory posts. How many of them are women? You have 90% women students in the class. How many of them are women? It is not particular to any university. It's happening everywhere. And a few years back when I met Chandrisri Pandit, when she became the vice chancellor of Jawaharlal Nehru University, she was telling that I was breaking 3 glass ceilings, and one is gender. For the long history of Jawaharlal Nehru University, for the long history of most of the universities in India, there was not a single woman vice chancellor. So you have to transform that politics. It's not about celebrating Indira Gandhi or talking about our president. So this transformation is not happening. So people come to politics, act in politics, work in politics. And again, finally, it's about celebrating gender. It's about celebrating gender. Being man and woman, male and female. There are certain things that have to be celebrated. In a larger sense, these are distinct identities. So this gender performativity can be transformed into gender celebrations. In that way, I think that, but it's a long-term project, not an easy project. And that should start from our classrooms, our homes, our universities, our training institutions, and our chairs. Okay, thank you, and I think that I have kept the time. Thank you for hearing me, and questions are most welcome. Thank you.
Yeah. Sir, Justice Chandra sir. So now we are having the response time to attend 20 minutes. For both the sessions, we will be having response time now. So I invite Chandra sir also to this. No, first sir.
Sir, Thomas sir, please, Thomas sir, please, let me make a clarification. One of your points that you mentioned, Ambedkar changed the name of his wife. Actually, it is not correct, because he did not change her name, but she changed her name by her own will, keeping according to the Bengali Brahmin tradition. Actually, Ambedkar called her Sharu, the same. Okay, you clarified. Do you have any clarification? So he never changed her name. It is by her own will she changed her name. Okay, this is the clarification. Okay, you got it.
Who changed the name?
Not working? Hello? Able to hear? Okay. I'm happy there was some response to my talk. The first question, in politically polarized society, can constitutional morality at best bridge or does it alienate public whose morality is being overrated? Personal bias versus public will. The question will be very, very simple. Once you are having a written constitution as to how this society has to be guided, and that receives the popular support, the question is whether the constitution permits the lawmakers to at least make changes in law. I can give you a small example. When the COVID pandemic was there was a lockdown imposed on the society. Nobody can go out, nobody can do anything. Now all the temples were also closed. Now when the temples were closed, there was a case filed in the Madras High Court saying the temples has to conduct pujas as per the norms, agamas, the ritual practice, and therefore we must open the temple. The court was in a dilemma. There is a religious right of a person and the larger protection given to the people on the basis of public health. Now there is a public health and the private right of worship. Now the court found a via media solution. The court said you can open the temple and do the pujas, but no devotees. Nobody will be allowed because gathering a group amount to increase in the pandemic being spread faster. And now this was something like a via media. You have your God, you can do all your worship, but then the gathering becomes a little difficult for a public health. Now the question posed was, does the public health override your private right? Now this is a question. Now if you look at the Constitution says all religious rights are there, right to propagate, right to believe, right to practice, and freedom of conscience, even right not to have a belief also. Very peculiar situation. Some of the advanced Western countries don't have such a right. I have a right not to believe. Nobody can question me. Now in these wider rights, it puts a smaller rider. It is subject to public health and subject to public order. Now these two considered to be a restriction were never considered against religion, because no religion wants their own follower to die out of a pandemic. Therefore this is something, a balancing trick which the Epidemic Diseases Act imposes some obligation on the government to put restriction. Now when you talk about constitutional morality, is it a bridge or it is an affront to the citizen if you say, now morality itself is something like a relative term. What is the morality after all? How does one evolve a moral aspect? Now what is the morality stands for? Now if you deeper analysis, each question has to find an answer. Now so far as our constitution is concerned, now we have also determined to eschew several prejudices. For example, our fundamental duty says any prejudice against a superstition or a prejudice against anything derogatory to women, now this should be eschewed. Now if there is again a conflict, now we have a direction, sense of direction, and that direction guides us. The guiding principle is the morality, and the letters of spirit is the law. The faith of the individual to the extent stand to guide the larger issue. All these issues are evolved taking into account the plural nature of our society, the mosaic nature. the multi-faith system, the different languages, different areas development. Unless you have a cohesive or a purposeful approach, you can never keep the entire society in a network of the whole of India. And therefore, ultimately, between individual freedom and a collective responsibility, there is something like a court act like an umpire. Now that umpire tells you this is good, this is not bad. And we got to live in a society which is ruled of law, not ruled by jungle. In that sense, you will have, for example, constitution faces a threat, not from the government. All right, government can be controlled by court. If the constitution faces threat from an extra constitutional group, that you wear this, you should not wear this, you should eat this, you should not eat this, or you should pray this time or not pray this time. Now this becomes a larger issue because in Karnataka, the government suddenly came up with a hijab rule for the school students. Now the question was whether hijab is a religious right or not. Why religious right was pressed into service? Because they felt that receives a greater freedom. But ultimately, the Karnataka full bench of 3 judges held that public order or the discipline or the same code within a school is more important than your belief. Now this is the final understanding of 3 judges in the Karnataka court. When the matter went to Supreme Court again divided into two judges. One judge who was a staunch fundamentalist, he said there is no religious right and therefore the state can restrict. This is one approach. The second judge, which is more the Sudhanshu Dhulia, he came with a very practical solution. Ultimately, why go into the issue whether it's a religious right or not? If the society in which they live or if the elders under which they are working, if they insist on wearing a hijab, the purpose is for the children to come to school and learn. By putting this restriction, are you preventing these children coming to the school or not? If your effort is to prevent children, then the question is it legal? Not adopted, that never be accepted. So the purpose is to make the children come to school and learn rather than a particular dress form that we impose on them in the name of uniformity. Now this is something, if the 2 judges are divided, it has to go to another bench. In the last 5 years, they have not constituted any bench. Therefore, we are still does not know whether it's part of a religious right or whether part of a right where a children has to come to school or a social responsibility. Therefore, there are many questions. In 1950, when we started the book with the Constitution of India as a rule book, there are many answers, there are many questions. Every question does not find an answer. Every answer do not satisfy the larger person. We still keep on evolving. Ultimately, the one test or the one process by which this could be resolved is what the morality test. Morality does not find a place in the Constitution. And then, as they say, social morality. You may have a moral, but then you live in a larger society. Therefore, the morals of yours is not superior to the larger well-being. In that sense, the constitutional morality test could be a better test than any other test, and that way that the system can advance. The next question is, in India, that is the name of constitutional literacy, only basic literacy, knowledge regarding fundamental right is given in the public. There are people who are unaware about the constitutional remedies, free legal aid at all. In this case, how can we educate and give an understanding regarding the constitutional morality to the public? I think the first approach, people are not so educated, they may not know. Constitution do not belong to lawyers and court. Constitution is belong to the people first. Therefore, to the basic understanding, people do not know the nuances of Constitution is a wrong idea because, you know, recently you would have seen when Rahul Gandhi, the leader of opposition, wherever he goes, he takes a copy of the Constitution. And that is printed by, that pocket book is printed by Eastern Book Company. the Eastern Book Company, which functions from Lucknow, last month they put that pocket edition has sold more than 1.55 lakh copies. It's not just bought by lawyers or not bought by the courts. Common people would want to know what is this rule that he's talking about. In fact, when he was speaking to some agriculture women in Bihar, he was showing the constitution. Most of the women are all agricultural laborers. He showed the constitution, said, this is the DNA of the Indian people. Now all the women were also clapping. For a moment we thought that do they understand? I think they do understand. For example, last elections in Tamil Nadu and all over India, the slogan of the BJP was, Aapki bar, 400 bar, that we will win 400 seats. In fact, Modi came to Madras, was saying everywhere, Aapki bar, 400 bars. So when he came to Chennai, it was in a bazaar, there was a road show, and Modi was going in an open jeep. And some follower started saying, Aapki bar. The Tamil Nadu people does not know Hindi, so they didn't know what to reply. Aapki bar means you must say 400 bars. But they saw so many ice cream shop, so they said Chaco bar. Whenever somebody said Aapki bar, he said Chaco bar. And then Modi got only Chaco bar. They got 240 less than majority. So people knew that they should not give them the majority, because the majority means you will pervert the constitution. And therefore, today the test is whether you want the constitution or you want to replace the constitution. This language, people do understand. When we go to people and explain to them the significance of constitution, we tell them the one finger rule that decides the destiny of this country. They well understand. I think what is to be incorporated is two issues: that India is a secular country and where everybody has a right to live. Maybe the educated people do not understand. We had a governor by name Ravi, something similar to your governor, who has now been shunted to Tamil Nadu. Now the Ravi is now gone to Bengal. Now the governor Ravi once said, I have gone to the constitution, I do not find the meaning of the word secular. I asked him, is the constitution a dictionary or a rule book? To give meaning for every word. If you don't understand the meaning, just look for the legal precedent, judicial precedent. If there are no judicial precedent, look for a dictionary. Now in Bombay case, 9 judges have very clearly said, secularism means that the state shall not discriminate between A religion and B religion. It will treat all religions together. It is not a theocratic state. It is a state where people can live, faith, practice, believe, and then propagate. This right is being granted. Now therefore, the plural mosaic of this society, if it is not kept, I think India will fall sooner or later, which we have seen in our neighboring countries. And therefore, this plural nature. Secondly, that we are given by a written constitution. Anybody who comes to power for 5 years or less than 5 years have no business to tanker this structure. That is why when I started saying Kesavananda Bharati's case, one of the main tests is a basic structure can never be changed. And when we have a faith on that, India will grow much more faster than what we have now. The second question is, what is your observation on the contradiction between social morality and constitutional morality? I do not think there is any basic contradiction between the two morality. Anything, if the morals can change, the morality can have not the same meaning, we can still go faster. When you say morality, do they have a monolithic morality? Or we have morality which change with the time? You take the case of honesty. Before 16th century, honesty was only a virtue. It was level of a virtue. After 16th century, some of the merchants going all over the world, they said, this virtue business will not do. We will say best policy. Honesty is the best policy now. When does the virtue become a policy? When does the policy become astray? It's all a question of society. Therefore, in a changing society, we are also bound to change some of the notions. Now, this 377 was there from 1860. 497 was there from 1860. Until some judges who examined the litigation found out, why should it be a crime? Why should anybody be threatened with a penalty for a normal action? Now, when the judgment came, there were people who were shocked. There were people who welcomed. For your surprise, you will find the Nas Foundation case decided by Delhi High Court received the world attention. There are so many high courts in India. There are so many cases. Why that judgment gets it? Because world over, they re-ask that question. A question which are already considered to be final are reopened. A word which is already final, it is deconstructed. And therefore, they find a new meaning. Now, in the Nas Foundation, Justice A.P. Shah and Justice Muralidhar were celebrated as celebrities all over the world for one simple judgment. All that they said was, sex is a preference. There is no question of state interference as long as there is a consent. Why should you be a criminal? Now we stand modified. Now, is it not the job of the parliament? That is what 2 judges said. But 5 judges said, everything cannot be led to the parliament. There is something like a review. If your law is bad, Article 13 says review the law so that it becomes subject to the fundamental right. And therefore, Nas Foundation was upheld by 5 judges. Now, what did the parliament do? When the parliament made a law, they omitted that section. Therefore, it could also be, as Justice Gawai said, it is not a question of who is supreme. The one supreme is the Constitution. And ultimately, it is the Constitution which is a guiding factor. And therefore, the concept of morality is something raised to the level of a constitutional morality. It only means that it is a fair approach to a wider section of society. Then there is also other questions which I'll go faster because your lunch is waiting. How to prevent Constitution from becoming judge-made law rather than people will political polarized societies and judges. One thing you must understand, when Article 32 forming the Supreme Court and followed by the power of the Supreme Court in several articles from 131 to 144. When introducing Article 32 into the fundamental right, access to court and judicial review, these are the 2 important tenets of a court. And for the first time in speaking in the Constituent Assembly, Ambedkar said, our court system, more particularly Article 32, is the heart and soul of the Indian Constitution. He has said that. What he mean by was, nobody is final. Ultimately, review has to be done. You make a law, I will examine whether it is right or wrong. Who will question? Anybody can question. 147 crore people, any one of them can say you are wrong and it will be reviewed by the court. And therefore, there is nothing like finding so-called contradiction between judge-made law. Ultimately, we appoint the judges with some qualification and then we expect them. And if there is a lower court is wrong, there is a higher court. If the high courts are wrong, there is a Supreme Court. Even in the Supreme Court, there are new system of review. Then there is a recused petition also there. Then there is a larger bench review is there. Therefore, ultimately, when a system made of individuals, ordinary human beings, it may sound to be weak, it may sound to be err. To err is a human. But we try to test and we continue to rest. For the last 75 years, Indian Supreme Court is able to establish itself, not going beyond. Sometimes it may transgress, sometimes it may not transgress. Ultimately, it is the Indian Supreme Court which is able to keep the whole nation as a one single network because of the judicial review power granted under Article 13. According to Hindu belief, God takes incarnation to re-establish righteous dharma. Yet in the name of God, some of the greatest injustices are taking place in the country. I don't think an answer in 2 minutes is responsible. The Sambhavami Yuge Yuge means whenever there is injustice, I will come back again and again. So we still wait for avatars. And that is why many times people don't take issues in public because they feel somewhere down the line. As I read in 1947, the Kumbakonam Women's Association says don't abolish untouchability. It's like a sin. What sin? Your birth is a sin. My being born as a Dalit is a sin. That I should continue to suffer untouchability. Then deaf or hearing impaired or visually challenged or a person who cannot speak are all sin. Now this is one notion of a religion, but then today it is not considered a sin, it is considered a challenge. We don't use the word disability, we use the word challenge. Physically challenged we say. Therefore the society looks in a different way. In fact, last year when the Supreme Court was opened, one girl from Kerala went to the Delhi. She was standing in front of the Chief Justice. She wanted to speak. Chief Justice asked her to speak. She can't speak because she's dumb. She's from birth, she can't speak. So somebody explained that she can't speak, but she wants to say something. Does it mean a person who can't speak has no right? The Chief Justice realized, for the first time, a great institution does not have a facility to transcribe what she's saying. So they appointed an expert. Today, if you go to Supreme Court, in the court, 2 experts are sitting all the time. If you are going to, can't speak, your sign language will be translated. That is why always when people say, my language is great, Sanskrit, there was a case came before me. Sanskrit is a language more closer to God. You can't have a Tamil pujas in the temple. So there's a language. I asked him, why do you say that the God cannot understand? He says, it's more closer. He said, do you have any inch tape to find out which is closer? He had no answer at all. Ultimately, God, which can create people who can't speak, he may also understand the signal language. Today, the Supreme Court allows people to say something in sign language, which could be understood. Now, this is never happened in the 75 years of Supreme Court. And therefore, what we consider as a sin, what we consider as a prior birth fault, all that has to change. And Ambedkar did not listen to Kumbakonam Women's Association. He brought Article 17. It had a resistance. There are many people who resisted. Even when the Hindu bill, which in my paper I mentioned, how much opposition. Even the very political party leader, Madan Mohan Malaviya, Surendranath Banerjee, the presidents of Congress party, and they were able to oppose. Don't bring a law. We know we got to evolve. They call Hindu phobia. Now you will find very, very ticklish question. California Assembly last year passed a law, BS number 403, equating caste discrimination with racial discrimination. Now, why should America pass a law? Why should the state which has got Silicon Valley, which has got software engineers, why they should pass a law? Because it's a physical fact. It's a fact they want to eradicate. Now, the major opposition for that bill came from, not from America or in Western countries. It came from the non-resident Indians, came from the Hindus. The All Hindu Foundation issued a statement. This is a Hindu phobia. Now the word Hindu phobia is not something invented today. In the Central Legislative Assembly, when Madan Mohan Malaviya and Surendranath Banerjee said, if the British government want to bring a change, we will consider it an affront against our religion. We will change ourselves. We do not change. We do not expect from change from outside. This was there. That is why I am saying that if you try to put everything on the question of faith, I do not think some of the past injustice, some of the past discrimination can never be abolished. And the Indian Constitution do not support any kind of a status quo apology for all these things, and we continue to work. In fact, following California, Seattle state also passed a law equating racial discrimination with caste discrimination. We are also having a law. People here are not afraid of those laws because we know our laws are fine on paper. Only in implementation we know how to get over. We are not afraid, but the Americans are afraid. The NRIs are afraid because their law can be potentially, it can work, and therefore there is so much opposition. We have a largest written constitution in the world. When we go to root, it is drafted by educated elite class and by educated middle class. Most of them were lawyers. It is a legal document which is created by lawyers, now being interpreted by lawyers. I do not think this is a valid charge. In fact, there is always, I was, as a student, I felt this, I have been brought in a Marxist tradition. I said this is a bourgeois landlord constitution, should be thrown into the Bay of Bengal, lock, stock and barrel. I have said that at the age of 20, but today if you ask me at the age of 75, I will not say that. I think one of the very beautiful drafted constitution, so much thought has gone. If you read the constitutional history, even the speech of Dr. Ambedkar in August 1948, 4,700 cut motions were given. 700 motions were pressed into service. 3.5 years of discussion. Notwithstanding their own discussion, they even called for, in fact, there is a recent book, how many representations they received from outside. And every minute and every second, they consider this country. And to tell you the truth, the original Constitution Assembly had 395 members, out of which 93 were Islamic representation. After the partition, after forming Pakistan, the Islamic members went to Pakistan, they had their own constitution. The Constitution Assembly was reduced to 297 members. Out of 297 members, 200 members were Hindus only. And why do they draft a constitution not declaring this as a Hindu country? They declared it as a country which is a secular, which had a religious right for every small section. Not even one small minority can have a right to their religious right. And therefore, they had the country in their mind. And therefore, the draft cannot be considered as an elite draft. And after framing an elite draft, it does not mean only courts are operated. The people who come to court are ordinary people. I know the hundreds of petitions which came to court were not drafted by lawyers. Even ordinary letters sent to court were considered as sacrosanct and treated as a letter petition, and reliefs have been granted. I can go on speak on the social action litigation practiced by the Supreme Court. There may be some setbacks. Every institution has got its own setback. No, never ever think that it is elite constitution. In fact, as Rahul Gandhi says, it's a DNA of the people, and there's a right to defend this constitution at this crucial hour, because there are forces which are trying to upturn the whole constitution. And therefore, it is a question of constitution versus no constitution. Our constitution was a newer version of the constitution. And therefore, I do not think it's a document of the elite, and I will never accept that as a... And if you see the other countries in the subcontinent, Pakistan does not survive with this constitution. The martial laws come in. Nepal is in problem, and Bangladesh, only new elections are held after an army takeover. And Sri Lanka declared as a theocratic state, Sinhala only policy, and only presidential form of government. So the only country which is still surviving with 106 amendment is this country. And to that extent, this subcontinent, we have won a constitutional goal. And I continue to believe in this drafted constitution. There are several laws for better functioning of this country, but now effectively, all those laws are implemented. How law versus reality? I think implementation of law is a larger question, which we'll have to keep on discussing. We always, as a student, used to say that there is a finer laws in our paper, but there is only a sadness in our society. And there's a gap between law and the practice still is such wide. It has to be narrowed, and that's the role of any social activist. Thank you.
Thank you, sir. On behalf of each and everyone, I extend heartfelt thanks to Justice K. Chandru. And due to shortage of time, I invite Srimati Lichi AJ to deliver vote of thanks for the second technical session.
Respected Chair, distinguished speaker, honored guests and dear participants. As Dr. B.R. Ambedkar rightly said, educate your women first and leave them to themselves. then they will tell you what reforms are necessary for them. I believe this powerful thought perfectly reflects the theme of today's session on gender perspective of Ambedkar thought. On behalf of Kerala Institute of Local Administration, I extend my sincere gratitude to everyone who contributed to the success of this session. I express my heartfelt thanks to Dr. Malavika Binni for chairing this session online and for her valuable guidance with Ambedkar thought and deeds. Your presence has truly elevated the discussion, ma'am. My special appreciation goes to Dr. Sabu Thomas, his enlightening and well-articulated presentation, which deepened our understanding of Dr. Ambedkar's vision on gender justice, equality, and women's rights. I also extend my gratitude to all participants for your active presence and meaningful engagement throughout the discourse. Finally, I sincerely appreciate all those who worked behind the scenes to ensure the smooth and successful conduct of this session. Thank you all.
Okay, thank you all. We can break for lunch. Kindly adhere to time. Please be on time by 2:45.
Hello? 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 Hello?
Okay, good afternoon. We can start our next technical session on social democracy in Ambedkar's view. This session will be chaired by Dr. Sindhu Tulasidaran, Professor and Dean, Faculty of Law, University of Kerala. She is an expert in constitutional law, human rights and related fields. We are honored to have her as the chair of this session. On behalf of everyone present here, we warmly welcome you. So, for this session, we have a distinguished panel of experts for this technical session. Firstly, we warmly welcome Srimati Vinita Singh, co-founder and managing trustee of We the People Abhiyan. She is having over 3 decades of experience in promoting active citizenship and social development. She has shared her insights on platforms like TEDx and various educational forums. So, on behalf of everyone, we warmly welcome ma'am also. We also welcome Mr. Arvind Shivan, resource scholar at University of Kerala and practicing advocate at High Court of Kerala, and is having specializing in constitutional law and human rights. Sir, we extend a warm welcome. So, a warm and heartfelt welcome to all our speakers, and I request all the speakers to adhere time schedule. All speakers have 15 minutes for deliberation, 10 to 15 minutes, maximum of 15 minutes for deliberation, and another 15 minutes for question and answer session. So, may I invite Dr. Sindhu Tulasidaran ma'am to begin the proceedings. Thank you.
Dear students, dear faculty members, dear friends, I know you have been listening to the different themes on constitutional morality and Dr. B.R. Ambedkar the whole day. So in this session, and I don't want to make the session so boring with my extensive lecture, so I'll only be discussing with you. We'll be having an interactive session. I'll be discussing with you the main aspects with regard to social democracy. And we have 2 other speakers also. So you'll be knowing about social justice. You'd have heard about social justice. And what is social democracy? You know that we have a democracy. Can we call our democracy as social democracy? We haven't been up to that mark. We cannot yet call our democracy as social democracy. I think so. We can call our democracy as parliamentary democracy. Okay. Our system is parliamentary. The mechanism is inbuilt. It is prescribed by our constitution. So we can call it as parliamentary democracy. It's okay. But do we have a social democracy in India? Yet we doubt, because we still haven't been up to the standard to become a social democracy. You know that a principle that is concomitant with social democracy is social justice. And whenever we think about social justice, the first person that comes to our mind is Dr. B.R. Ambedkar. Because as we all know, he stood every time for the sake of social justice. You know how he has enlightened us with the principle of social justice. What has he done for bringing up social justice in India? It is a constitution which he has drafted. He was the chairman of the drafting committee of the constitution. We had a drafting committee, but almost all the work was done by Ambedkar. He shouldered the major responsibilities of drafting a constitution. So you know that in our constitution, we begin with the resolve by the people to build India into a sovereign democratic republic for securing to all its citizens justice. What type of justice? Justice, social, economic and political. And for that, we will have to attain the major attributes of justice which comes thereafter, that is liberty, equality and fraternity. So we will have to achieve liberty, equality and fraternity. So liberty of thought, expression, belief, faith and worship, you know that. Justice, social, economic and political. So we can call or we can consider social justice as something that is ensuing from social democracy. If we want to have social justice, we should have social democracy. In a social democracy, what precedes is public interest the most. Public interest or societal interest precedes the individual interest. So in what type of society do we have? For that, we will have to have a democracy in which justice, social, economic and political shall pervade. So justice, social, economic and political. We know what is social justice for all of us, that is whatever is there, that should be distributed equally among all. Whatever we have, we shall have that to be distributed among all equally. That is what is socialist pattern means, socialistic pattern means. Then why do we go for economic justice? Justice, social, economic. Why has economic come second? So because we have a parliamentary democracy, we were having the responsibility to set out our goal. What would have been our goal? We thought about that and we considered it as economic justice. So if we have to have social democracy, we will also have to set out our goal of implementing economic democracy. So what type of democracy is economic democracy? Some people argue that it is individualism that best suits with economic democracy, and some people argue that it is the socialistic pattern. Some says that it is a communist model that is best suitable for an economic democracy. Anyway, we are striving to establish an economic democracy. We haven't yet achieved it fully. We have achieved it partly, we can say. So we have justice, social, economic, and thereafter we come to political justice. Justice, social, economic, and political. If we have to have economic democracy, or if we have to achieve economic democracy, we will have to have one man, one vote. We will have to come ultimately to one man, one vote. So we can say that justice is multifaceted. It has many faces, and no component of justice can be drift apart from the other. It cannot stand apart from the other components. So it cannot be said to be mutually exclusive. It could only stand together. Always justice will be multifaceted. We can't say justice only as social or only as economic, but we can call justice as something that contains all this, that is social, economic and political. Only if we have all this, we can call it as full justice. So that is what is social democracy means. So Ambedkar stood for social democracy. You know that we have fundamental rights, people have political rights, we can call it as political democracy. What type of rights do we have? We have many political rights. What are its restrictions? We will always subject it to social order, isn't it? Public order and morality. We will always restrict it to public order and morality. So what is public order? We can't enjoy our individual rights by destroying or by affecting the public order, isn't it? Any right, if you want to enjoy any right, we will have to have the public order. We can enjoy it only without upsetting the public order. And always sovereignty should be respected. So where we have gone for sovereign democratic republic, that was for the sake of securing to all our citizens justice, social, economic and political. And we can say these are the attributes of the principle of justice, that is equality, liberty and fraternity. And it is for the first hand for assuring the dignity of the individual. Why do we go for liberty? equality, fraternity, all these are for assuring the dignity of the individual. So individualism is most important, and thereby the unity and integrity of the nation. So we have constituted India as a sovereign socialist, sovereign secular democratic republic, so as to make it, what you can say, as a unified whole. So everything is resting on the will of the people. You can say that India is an organized entity. India, as we constitute the sovereign socialist, or originally it was only sovereign democratic republic. Sovereign democratic republic as an organizational entity, a single organizational entity, from where we derive the power. That is, everywhere the power vests in the people. Even for units, for states, the ultimate power vests with the people. State also derives its power from the will of the people. So sovereignty ultimately vests with the people. So for this, Ambedkar stood for till his life. You know how Ambedkar struggled through his life and how he has reached to the highest echelon of his life. You know that Ambedkar defines constitution as the social charter or document, which is strong enough to convert the medieval hierarchical society into a modern egalitarian democracy. So medieval hierarchical society was later transformed to modern egalitarian society. What do you mean by egalitarian society? Egalitarian society means, so we can think about justice. For justice, we'll have to have equality of status and opportunity. So egalitarian society is a society in which all enjoy equal rights. All are equal in status and opportunity. So what we want to have firstly is equality of status and opportunity. So we can say equality is a direct attribute of justice. So we think about social justice, the first thing that comes to mind is equality of status and opportunity. All should be given equal opportunity. So equality of opportunity is the first thing or the first attribute of social justice. And for equality of opportunity, we will have to bring certain communities forward. That is, those communities which have not yet been able to enter into the administration of the state. And for that, we have included affirmative action or positive action, can call it as positive action, for the sake of bringing in reservation, for bringing in these communities to the administration of the state. So first, that is only for a minority, that is not for all, only for a minority seat. If it is for the admission to civil services or state services, it is meant for a minority of seats only. It's not for the whole seats. So we can say there should be equality of opportunity. All should be given equal chance. But in some cases, whenever we find someone not able to enter into not having entry into the administration of the state, they should be given, or some positive action is required, or some affirmative action is required for that, and for that we have introduced reservation. So provision for one is equality of status and opportunity. All should be given, all should have equal status in a country where social justice prevails. And there all should be given equal opportunity. At the same time, some should be given some affirmative action is needed to bring certain people to the forefront. And that is what is meant by reservation, and it should be confined to limited number of seats only. We can't give it to a majority. We can only give it to a minority. So that is what is meant by affirmative action, and affirmative action was originally you know that constitution was at all times considered as a social charter for transforming the society into a modern equality-based society. And for that we require affirmative action, but that was considered only for a short period. What Ambedkar intended was that this should stand only for the first 10 years. And thereafter that should be removed. And for that we began affirmative action. And since we were not satisfied or certain, we still doubt that we bring into our arena, the arena of constitutional issues, we have brought in concepts like creamy layer. Why have we brought in concepts like creamy layer? Because certain people have to be avoided, isn't it? So those who have achieved equal status and those who have already enjoyed equal opportunity or have already got a equal opportunity should be removed. And those who haven't yet attained that level should be made to come in. So for that, a creamy layer concept was introduced, and it was suggested that creamy layer should be removed from those people enjoying reservation. So that was also considered by Supreme Court. And creamy layer is in the, what is in the way of implementation. In many states, it is seen implemented. The income criterion has also been determined, but we don't know how far it has been implemented in many states. Is it been properly implemented, or is it time to stop reservation or to give reservation to the proper people? If proper people hasn't yet received reservation, then they will have to be brought in, and not the third generation enjoying the reservation. We'll have to find out the first generation not enjoying reservation. So that was what the concept of social justice intended by Ambedkar. And many of our constitution makers were for such type of affirmative action, and we don't know how far our reservation policies are fulfilling that objective. Anyway, we will have to think about it, we will have to study upon it, we will have to conduct a research on that, and if you want to revise it, it is time for revision of the reservation policies. So we know that social justice is there for implementing, we have parliamentary democracy, that's a good mechanism. In a country like us with such diversity, always parliamentary democracy is suitable. And along with parliamentary democracy, we'll have to proclaim a goal, that is economic democracy. And through economic democracy, we'll have to achieve political democracy. So that is what is the scenario here, and we shall have to begin from social justice. So social justice is the primary factor that has to be brought into in society. We know that societal interest has to precede. And when I say societal interest has to precede, we'll have to think about the directive principles. Are directive principles equally important as fundamental rights? And we say part 3 is more important than any other part of the Constitution. Have you ever thought about directive principles? You go through Article 38, what does it say? What is the intention? The state shall strive, it starts with the words, the state shall strive to establish, or state shall strive to promote welfare of the people in such a way that it shall secure a social order in which justice, social, economic and political shall inform all the institutions of national life. So what is the responsibility of the state? It is for the state to strive. Why is the word strive inserted? It was the, the intention, or who stood for the word strive was Dr. B.R. Ambedkar. There should be the word strive, because otherwise the government can stand apart saying that there is no, the circumstances won't permit us, or else they can say that finances are not adequate for us to go through this way. So we feel some factors which are not conducive. All this can be arguments which the state can bring against implementing the social order that is required in a society. So what the word inserted, strive, was very apt there, because the state has the responsibility. It is mandatory that the state should maintain or promote or establish, secure and promote a social order in which justice, social, economic and political shall inform all the institutions of national life. So it's a responsibility of the state. It is a part of directive principles, but at the same time, though it is non-justiciable, the state has the bounden duty to bring about a social order in which justice, social, economic and political shall inform all the institutions of national life. So you can say how a directive principle has been inserted. A directive was given to the state to bring in social justice through a directive principle of state policy. Even though that is non-justiciable, that has become the most important provision of the Constitution. So that is why we can say that in certain respects, directive principles are more sacrosanct, or else we can say are more important than fundamental rights. They mean much than fundamental rights. So that is what Ambedkar has also said. There should be the state there to take effort to implement such a social order. If we can implement such a social order and bring in all the necessary things and the necessities and the deserved ones being given the resources that should be made available to them, then we can build in or we can bring in a social order in which justice, social, economic and political shall inform all the institutions of national life. So simply if we go for a political democracy that won't work, because it is only a mechanism. It is only a mechanism, though it is contained in the constitution, it is only a mechanism. What we have to have is a goal for our governance, that is economic goal, economic democracy. And for economic democracy, the state shall take effort to bring in a social order in which social justice can be imparted to the people. So we can bring in reservation also in such a, we have brought in reservation in such a manner. So if you want to have changes, if you think that the policy should change and it should reach the deserved ones, if the deserved ones haven't yet received the benefits, we will have to revise the policies, whether income should or economic criterion should also be brought in along with caste. We know that caste says about social and educational backwardness. It's an indicator. It is an apt indicator, but at the same time, whether economic criterion should also be considered. So all these are there for us to think about, to search for the concept of social justice, which Ambedkar has imparted through the constitution. Even Ambedkar was hesitant to include or to keep reservation policy or to keep the provision for reservation for all the times to come. He was only suggesting for the concept of reservation only for a short period. But if we haven't attained the goal, we'll have to think about it. We'll have to see if the deserved ones are getting the reservation or not. So that is what is called social justice. For social justice, all these should be there. That is equality, liberty, fraternity. So you know that all these were adapted from different constitutions, were made adaptable to a constitution, adopted from different constitutions, different scenario. That is, you know, from Russian Revolution, we have taken justice, social, economic, and political. And from the French Revolution, we have taken liberty, equality, and fraternity. So all these were experiences that were that were brought in by Ambedkar into a constitution, which he thought would be appropriate to our circumstances. And we know that social justice is a variable thing. It will vary, it will have to change with respect to the different circumstances. So we'll have to think about the different circumstances. If the circumstances are changing, we'll have to see how that can be got implemented in a country. And we can go through a number of decisions on that. And all these show that there should be some sort of refinement or some sort of rethinking on the concept of reservation to achieve the exact social justice as intended by Dr. B.R. Ambedkar. So I think I'll stop this for the time being, and now I invite next speaker, Srimati Vinita Singh, We the People, Abhiyan, Haryana, to present her views.
Ma'am, is it audible? Yeah. Ma'am?
Yes.
Yes, ma'am.
Can you hear me?
Yes, ma'am. Yes, ma'am.
Yes. Thank you so much. Thank you. It's really lovely to be able to be here for this session with all of you, and I hope that I'll be able to manage because my laptop does not have a camera, but my phone does. So I will try and manage between the two. So thank you very much for the introduction to social democracy. I wanted to present a couple of slides for people to be able to just get a picture of some of the people that have actually made this fight for social democracy possible. Um, can I just, for the moment, just share a couple of slides and make it possible for you to see a couple of faces that I want you to see.
Yes, ma'am, sure.
Can I please share?
Yes, ma'am.
Please allow me to share the screen.
Ma'am, you have.
Are you able to see it?
Yes, ma'am.
Okay, that's
Can you make it as a full screen?
yes, I'm just doing that.
Yeah, yeah. Okay.
Can you see it now?
Yes, ma'am. But if it is on full screen now, it will. Yeah, yeah. Now it's okay.
Okay. So I just wanted to introduce Abdul Rahim. Are you able to hear me? Hello?
Ma'am, I think you are using two systems at the same time. That's why echo is coming.
Okay.
Yeah.
Okay, so let me not try and give such echoes to the whole team here. But let me just tell you a little bit about somebody that we work with very closely. And you just saw her, but I wasn't able to show you fully. Who you met just now on the screen was Abdul Rahim. Abdul Rahim is from Jabalpur in Madhya Pradesh. And uh, basically, she has been trapped in a man's body. From the time that she was born and when she was able to get a little bit more sense of who she was, she believed that she was cursed. Cursed by the system, cursed by people around her, also beaten, wasn't given food as she grew up. She didn't have any opportunities for jobs. Whenever she went for an interview, it was always her identity that came in the way of her placement. Imagine your life where you're not able to get a job, people at home are not ready to support you, and yet you must fight because you believe that your identity, even if not accepted by society, is still your identity. Abdul Rahim, actually now she goes by the name Suhana, did everything that she could to be able to get people to accept her the way she is, and found her own community, fought for the Transgender Protection Act, and through various means enable people from her own community to have identity cards. That identity, which was denied to her and people like her, was what she was able to make available to many of the people in her community. There's also another friend of mine, people we work with, Bhanu. Bhanu also comes from Madhya Pradesh, from a tiger sanctuary in Madhya Pradesh called Panna, and she lives very close to that sanctuary. Very early in her life, Bhanu had a case where she was sexually harassed. Like many people who would have probably been quiet about it, Bhanu wasn't like that. Bhanu decided that she will file an FIR and gun for this person who actually was the perpetuator of this crime. It took her a lot of effort, many weeks, months, years of follow-up, but she didn't give up. She is actually called the tigress of Panna because of what happened after this. Bhanu ensured that the perpetuator of that crime, the accused, went to jail, got 10 years in prison. Not only that, Bhanu actually worked actively with people to help those who have had the same treatment meted out to her, who have been sexually harassed, and ensured that they are able to also file and follow up on FIRs and ensure imprisonment to the perpetrators. 65 women. Sometimes it feels, what is 65 women? But if you think of these women as women who were not able to even stand up and point out the crime, then to be able to get these women to actually go out there and ensure that justice is delivered, then 65 is a huge number. Now, why am I talking to you about Bhanu and Abdul? Why? Who are these people? The reason why I'm sharing these stories with you is because both Bhanu and Abdul have fought for equality, for being treated equally, for being there as people and recognized as people equally. And to my mind, both of them are doing what Ambedkar wanted. Ambedkar actually gave a direction when he said, democracy is about bringing about revolutionary changes without bloodshed. And this is what Bhanu and Abdul have done. They're not the only ones, surely not the only ones. We the People Abhiyan, the organization that I work with, has been working with many such individuals, people. More than 10,000 people who have fought the fight for equality in different parts of the country. Rajasthan, Madhya Pradesh, Uttar Pradesh, Bihar, Jharkhand, Maharashtra. And these, when I count even these, they're just few amongst the so many innumerable people who are standing up and fighting for equality every day of their lives. In my opinion, Baba Sahib would have lauded all of these people, as he was clear that equality is the essence of social democracy. In fact, when he talked about the ideals of equality, freedom, and fraternity, he placed equality as the central piece. Because according to him, without equality, even freedom and fraternity cannot be achieved. How can people be free if some of them are treated as superior and some as inferior? That doesn't mean that they are free. They can't be free. And how can people have fraternal feelings of fraternity if they are not equal? So when we think of social democracy, to my mind, the very essence of social democracy, is equality. Social democracy equals equality. Further, Dr. Ambedkar recognized that equality as a moral ideal is even more necessary in a society where inequality is internalized. What does this mean? It means that the social groups, people that we are part of, the community that we are part of, in fact, in social life, we do not even recognize that there is an inequality. It is internalized in such a way that when it occurs in front of us, or when we also do it, because we are part of social life, we are not removed from it, that even when we do it ourselves or we experience an inequality happening, sometimes we may not even recognize it because it is so internalized. And that is why Bhanu's struggle and Abdul's struggle is even more important, because it is in a state or in societies where inequality is internalized to a level that it may not even be recognized as something that is of concern. Bhanu, when she was sexually harassed, her family said to her, leave it, it's okay. Nobody will come to know, it's all right. We don't want to let anybody know. But in that environment, when people are not even recognizing that you have been treated unequally, that a man would not have had the same treatment or the advice that Bhanu got, in that society to be able to stand up, I think Baba Saheb Ambedkar would have been very, very proud. So what does this tell us? We have heard, and you will hear, more speakers talking about what social democracy means. What does constitutional morality mean? And we understand that social democracy, is a state where everyone feels equal, right? And equality, freedom, and fraternity are the hallmarks of such a space where social democracy exists. But what can we learn from it now? What can we learn from Bhanu, from Abdul, from what Baba Sahib is telling us now, today, in this time? According to me, there are three things. One is that social democracy is work in progress. We have not achieved it. I'm not sure if we will achieve it. I'm not sure if anywhere we are able to achieve it in this country. But we do know that many Abduls are needed. We do know that many coalitions are needed of such people who are fighting every day for these ideals that Baba Sahib Ambedkar set out. It means we need cooperation, we need networks, we need to recognize that people who are standing up, even now, today, are extremely brave, and they need to be appreciated, they need to be supported. I think if Baba Sahib Ambedkar would have been here today with us, he would say, organize all these people, get them together. Let us fight the good fight together. The second thing that I believe Dr. Ambedkar would be telling us is that let's look about us. Let's look about us at those inequalities that have been internalized. People in Kerala, a state that is so advanced in terms of various parameters, and a state where I think Baba Sahib Ambedkar would have been proud of. A state where so much advancement has been made in terms of bringing equality in social life. Yet, it is very important for us in Kerala to look about us and see which inequalities are actually internalized in such a way that we don't even recognize it. What is the next step for us in terms of social democracy? Which is the new milestone that we have to reach as a society? Which are those conversations we have in families which are not available in public life? Which are the conversations around equality that we must have even in a state like Kerala? The third thing I believe that we should be asking ourselves with relation to social democracy and the vision that Baba Sahib Ambedkar has given us is, what kind of role can the people of Kerala and Kerala as a state play for all the people in the rest of the country who are fighting these good fights? And I would ask, can we be more available to people? Can we be more supportive of people? Can we understand which inequalities are existing in so many different contexts? Yes, we have, from our context in Kerala, moved on to have many, many milestones achieved. What about the milestones that we need to achieve in different parts of the country? What about milestones that we need to achieve in Madhya Pradesh, where Abdul and Bhanu are fighting? Can the International Academic Chair, Baba Sahib Ambedkar International Academic Chair, actually document these stories of people who are fighting for equality, fighting for social democracy? Can we appreciate these people? Can we bring them together? Can we have a whole narrative about them? They may be not as many as how many are needed. Many more revolutions are needed. But can the International Academic Chair play a role? Can the people of Kerala play a role? Can all the people of this country who are concerned about social democracy play a role in bringing many, many more revolutions? I can tell you that Abdul and Bhanu have unleashed a revolution. There are many such revolutions hidden in plain sight. Can we make them visible? Can we make them available? Can we make them such that they inspire many more Bhanus and many more Abduls? Can you, who are in the room today listening to me, can you take these stories and bring them to your own life to look at inequalities that are so ingrained, but that we must uncover and question, and thereby create more revolutions that Baba Sahib Ambedkar, I'm sure, would be looking down upon us and saying, yes, this is the India that I fought for. This is the India that I made the Constitution for. This is the India that I'm proud of. I stop my submission here.
Thank you, ma'am.
Thank you.
Now I invite Mr. Aravind Shivan to share his views.
Good evening, all. It's very delighted to back to home. That I always cherish this hall very much, and due to the constraints of time, and subject is vast and deep, and time is too short. So, I would like to invite your attention regarding how the Ambedkar's vision upon social democracy, as the practical manifestation has been explained by the previous speaker, and how it has been incorporated through the modes and principles of federalism. How federalism has helped in attaining the goal of this social democracy. And there are many critics, many enhancements or many opinions regarding there is no pure form of federalism. How can we include an absolute concept in a very diverse nation? Different types of cultures, linguistics, different customs, and all these aspects, and all these different areas, different sects, different thoughts, and how all these people can be united into a same and one India. How can we incorporate this diversity? How can we embrace this diversity? Ambedkar had the answer. By first, he introduced the foremost concept, which is only a relatively discussed, but is of very relevant in the time now, as many issues are coming out, and lot of the people, or most of them, does not have a shoulder to lean or to be heard, and the concept of fraternity is achieving such relevance. See, the relevance of fraternity that is being imbibed, that has been incorporated through the concept of federalism, how it is being done. See, when we look upon the childhood, when we talk about social democracy, when we look upon the childhood aspects of Dr. B.R. Ambedkar, see, no child shall go through such a trauma. So how, when we look upon the biography of Ambedkar, on what are the things that he had gone through, and that is the change that have made a person into an Ambedkar who brought such changes, but that have created an unhealed wounds to Dr. B.R. Ambedkar. So I heard that some students of psychology is also present there. They are trying to translate the Mental Health Act 2017 into Malayalam, right, in the local language, to be heard and understood by many of the people sitting here. Yes, it is to be understood. What is the aspect of mental health? How it can be related to fraternity, and how that fraternity can yield the goal of social democracy through the concept of federalism. And through the questions or the deliberations of the CHRD, that is the Constituent Assembly debates, Ambedkar has made a very famous speech regarding when we are being submitting the document before the people, that is we the people, the popular sovereignty. It's been said that we are going to enter into a life of contradictions, different diversities, and how this equality, the political equality, can be attained through this constitution. But what about the social and economic equality? How this can be attained? And if that is not been answered, if that is been left unanswered, then the political democracy which the Constituent Assembly has so laboriously built up through the Constitution will be in vain. And also to make a nation which is having a different, no common feeling or no common interest, cannot be a nation in the real sense of the word. And through the concept of this pluralism, through the concept of pluralism, the entire diversity is being embraced and integrated into the one concept. And that has been answered, their queries, by our answer to the concept of equity. More than equality, this is equity, that is equality plus justice. And through that concept, through the equity, the goal of fraternity is being incorporated regarding in answering the issues of this diversity or of not having a common sense or common sense of unity. And during the time of this government or the constitutions being framed, Ambedkar is very well known about the factors that were present during the time. That is the communalism, linguistics and regional differences that threatened the new nation. So he gave a resolution that how about a federal constitution with a unitary bias? That formulation is been generated extensive scholarly debate, though he is not supporting, he is giving the entire power to the union. But on careful reading, when we do a careful reading on the aspect of a federal constitution with a unitary bias, we can find a coherent social democratic logic. And then the draft speech, we can identify that, quoting Ambedkar, though the country and the people may be divided into different states for the purpose of administration, the country is one integral whole, and the people a single people, living under the single imperium derived from the single source, that is the Constitution. And the federalism can act as a shield against the caste oppression. How that can be done? That is through the constitutional safeguards. He argued that federalism, if properly understood, must serve as a structural guarantee against the tyranny of local majorities. And that is the socially responsible federalism more than the cooperative federalism that we have to focus upon. Socially responsive federalism, the term was coined by the veteran, the eminent jurist MP Singh. The socially responsive federalism, more than the cooperative federalism, should be there to address the centralizing tendencies and also in addressing the discrimination that we find in our nation. So the intervention of the center must be deemed, if the center has been intervening or interfering in any matters relating to the personal life or the fundamental rights of the people, it should be legitimate and desirable, and for protecting the fundamental rights of others. If one's right is being violated, then the government or the fundamental rights should be protected of that person, and by the state can impose on certain and act upon the others, can curtail or restrain the right of the individual in a legitimate and desirable manner. And through that idea, or through the vision of this Dr. B.R. Ambedkar, it goes through this transformative constitution that we have been witnessing right now. Through the landmark cases from Indra Sahni, the 9-judge bench grappled directly with Ambedkar's legacy in the context of reservation. While talking about the few illustrations, the real illustrations of Madhya Pradesh, I would like to bring before you the concept or the fight that has been brought by the Vishaga, the non-governmental organization for Bhanwari Devi, and how the organization stood for the right to work in a peaceful atmosphere without getting addressed, without getting sexually harassed in a workplace. And what are the elements that can include into the sexual harassment, and what are the safety measures that should be provided in a workplace? These aspects of social democracy, respecting the dignity of one's self. And that is why right to life is not mere animal existence, according to Ambedkar. It is the life with dignity and liberty that should be strengthened upon the fraternity and should have a sense of brotherhood. That is how the dignified life that should be led by each and every one in this world. And that aspect goes to another pedestal where it is being considered as to have compassion towards the living creatures. Not only the human beings that we see, but to have a compassion towards living creatures also. And how did that compassion arise? Through the concept of social democracy, through the concept of fraternity, and that has been included in the fundamental duties. And moreover, when we look upon how the case laws like S.R. Bommai, where the federalism is a basic structure of the Constitution. Secularism is the basic concept of basic structure of the Constitution, and how the common sense of brotherhood and how we define the secular aspects. Secularism, in its proper sense, is a negative, is a negation of religion from the politics of the government. But in India, on embracing the diversity, secularism is the respectful indifference towards the society or towards the religions. The government will be respecting the religion, but there will not be any official religion on the aspect. And that respectful indifference will help the government to work upon an impartial manner and in an equitable manner also. And through that, the relations or the intergovernmental relations where between the state governments and the central government should be governed by the imperative of social justice than mere administrative convenience. That can be found in the state of West Bengal versus Union of India versus and a lot of the plethora of cases till the GST cases. We can identify how the cooperative federalism helps through the weapon or through the instrument of social democracy to achieve that social and economic equality. And as the chair and as the previous speaker has spoke upon, the social equality or the social democracy only partially being manifested. We have still long way to go through to address the social inequalities that is getting sophisticated in many areas, but in the virtual areas also, in the social medias itself. We look upon the physical plane and what are the things that has been affecting the inequality, the opportunities of equality. And in the social media, in the cyberspace also, there are the gap of the digital divide that has been happening. The comments that we make in social media, and that has been addressing, that's been wounding the dignity of every individual, the comments that has been made. And are we taking things for granted as the deliberations made by the framers of the Constitution? They took a much big labor to make this social document, the living document, the organic document, to be manifested in each and everyone's aspirations, to address each and everyone's aspiration. Are we taking it for granted by intentionally ignoring the social inequality, by intentionally hurting the sentiments that is being legally constrained? Are we of becoming a much more than a human, and we are behaving like an animal, and that is not, we should not do that, as humans are also a social animal, right? And we are forgetting the aspects of the principles that we embrace through the French Revolution, Russian Revolution, that is being included, enshrined in the preamble of the Constitution. These things have to be kept in our mind. Har dil mein Samvidhan. In every heart, the Constitution, the principles of Constitutions shall beat. The heartbeat should be the principles of Constitution. And each and every corner of this institution we can find, the secular hall, the preamble that we see when we rise up the stairs. And all things that remind us the social democracy is the goal yet to be achieved. And it should be understood, should be followed through the principles of the Constitution. And the economic democracy and the question of the economic democracy and social democracy, this has to be understood that there are debates that has been happening on how the cooperative federalism has helped in an extent to address the economic democracy. But the rights of the states, the scope of the constitutional morality, and the persistence of the caste-based discrimination that is still prevalent. The Ambedkarite jurisprudence framework retains its urgency. As Ambedkar itself warned, the contradiction between the political democracy and social inequality cannot long endure. The task of jurisprudence or the system of law, therefore, is to animate to constitutional text with the transformative social vision of its principal architect, that is Dr. B.R. Ambedkar. As I'm concluding now, thank you so much. Thank you.
we are having a question and answer session. So Vinita ma'am is also online. So if anyone has questions, now it is time. So we are in short of time, so if any questions, no, please come forward.
Madam, in your chair address, you are telling about affirmative action. And you are telling that it's based on some time frame. But I am on the other side because this situation was created by a history, a long history. How we can overcome these issues in the span of maybe 10 years, 20 years, just get by 1,000 years. So I think that putting that kind of time frame, seeing your time frame is, well, it's okay.
It's because, there should be social justice. Social justice should be there, but a balance has to be stuck between social justice and efficacy, that is meritocracy. So you'll have to have a balance. We have to have a harmonious, a relation between efficiency and social justice. So if we want to have that, efficiency should also be there. At the same time, we can have social justice also. If you are sure that we have achieved it, you can stop it there, because even constitution makers have intended for that only. Because make our country prosperous, make our country full-fledged, and for that we will have to provide equality of opportunity to all. If we haven't provided, we will have to make more provisions. Where we have found a lacunae, we will have to bridge that. So even in the case of SC, scheduled caste and scheduled tribe, and as well as backward classes, why have we introduced the word backward? So we'll have to say who are the backward, we'll have to assess who are the backward, whether it is reaching the true backward class of citizens. So backward was intentionally inserted, and whether that is reaching the backward, then why haven't we achieved social democracy yet? What are the hurdles to our social democracy? So we have social hurdles, we have legal hurdles, we have political hurdles, we have economic hurdles. All these have to be, we have to remove all these hurdles. And for that, at the same time, we'll have to have a balance struck between efficacy as well as social justice. So there should be efficiency. We'll have to maintain efficiency. Who is reaching there? If the deserved one is reaching there, there is a cap, 50% cap is there, and that was insisted by the Supreme Court also, but we will have to go above that, whether that is reasonable. So we'll have to think about all this. So we can't, we can't say that efficiency won't be there. There should also be, there should be reservation, but at the same time, we should have a a balance struck between these two aspects. We should have social justice, at the same time we should also have to give importance to efficiency. So all these should be there, and the correct people should be there. If they are not the correct people, if someone is enjoying reservation in the third generation, while certain people are not at all coming to the forum, then that should be rectified. That is what is called economic disparity or economic hurdle. So that should be rectified. If the first generation should also be able to come. But many times third generation would be coming, but the first generation of certain sections won't be coming. Even the first generation won't be coming. So we'll have to take into account all these aspects. Whether there is social barrier, we'll have to remove that hurdle. If there is any other barrier, if there are more legal reforms are required, we'll have to make more legal reforms. So whatever is necessary, we'll have to have that in our system. If this is workable, it is okay. Whether it is working or not is the problem. So all these should be there. At the same time, we will also have to give importance to merit. Merit should also be there. We shouldn't go above 50%. So all these should be taken into account. So if everything is going to be as a part of reservation or efficiency is not at all coming, not at all considered, then that will also be doing, whether we are on the wrong path or we are in the right path. Whether that is disastrous to the social democracy, that is also a question. So all these should be attended, all these should be in our mind when we revise our policy. That's what I said. So if all are coming, okay, whether Mizoram or those in Northeast are coming, whether only those in South are only coming, whether only in the central, the Indian people, the central provinces are coming, those who are residing in Bombay, those who are residing in the metro cities are coming, but those who are residing in the northeast areas, in the hilly areas, whether they are coming into the plain. So all of them should be brought to the plain, and then only we can say that reservation is effective. So we'll have to see that, whether that is doing good for a country, whether we are becoming socially democratic. If it's okay, it is best. But if it is not okay, many a time we find that why certain people are always being at the same level, they are not at all getting elevated, while many people are enjoying reservation beyond their situation or their level has risen, but still they are enjoying reservation. So that has to be attended, that issue should also have to be taken into account.
Madam, then again there is a problem. When we talk about merit and meritocracy, the merit is a creation of history. Everything is a creation of history. So you talk about 3 generations of maybe first generation, third generation, but it's a creation of 30 generations, 300 generations. And again, when you talk about maybe wrong things are happening, wrong people are in wrong place, see, all these people are here for 1,000 years, 3,000 years. Then now you are telling that you have to remove them in 2 generations. It's not about Kerala. It's a global situation. Wherever you talk about.
There are anomalies. We all know that. All of us are aware of that, but we are not, actually attending to such factors. We are still aware, but even then we are hesitant to speak about that. So we'll have to have that in mind, whether it is full-fledged, okay, but we know that it is not full-fledged. The same people or the same generations, one after the other, are enjoying the same sections. Whether poorer sections of the people eligible are still there, not having even enjoyed in the first generation. They are not at all enjoying reservation, but some are continuously enjoying.
Okay, thank you for the wonderful session. Now I invite Dr. Dhanusha.
I just wanted to say thank you to the chair.
Thank you for your excellent presentation.
And also to my co-speaker, thank you so much for having me here.
Okay, I invite Dr. Dhanusha to deliver a vote of thanks.
Good afternoon, everyone. As we conclude this thoughtful second technical session of Ambedkar Memorial Annual Lecture Series, it is my privilege to propose the vote of thanks. On behalf of Ambedkar International Academic Chair, first and foremost, I would like to express our deepest gratitude to our chair, Professor Dr. Sindhu Tulasidaran, Dean, Faculty of Law, University of Kerala. Thank you, madam. For making the ideas and visions on social democracy very clear. And she also mentioned the reservation policy as a tool of social democracy. And she emphasized primarily on it is time to reevaluate and rethink about the reservation policies, how much it achieved, and also the participation, the social, economic and decision-making participation of different caste category. Thank you, ma'am, for enriching our ideas and understanding. A special thanks to our distinguished presenters who brought diverse and valuable perspectives to the floor. Srimati Vinita Singh, we the people of Habyan, Haryana, for your insight into the ideas of equality and social democracy. And now I would like to express my gratitude to Sri Aravindas, research scholar, University of Kerala, for your thoughts on fraternity and social democracy to the academic dialogue. Finally, I thank all of the participants and audience, to the scholars, students and attendees for your active listening and thoughtful engagement. Thank you all. Have a great evening. Now I would like to invite Dr. Sindhu Tulasidaran ma'am to receive a small token of appreciation from our beloved CHRD Director, Sri Sudeshan sir. Now I would like to invite Sri Aravindas for receiving the memento. Thank you.
Hello, Vinita. Namaskaram from Kerala. Okay, thank you for joining in this wonderful session. I was very impressed with one of your comments that social democracy is effective if we make some revolution. So that point is very important. So generally we fight for political democracy. There is no fight for social democracy. It's a very impressive point that you made in your presentation. So now I am thinking of how to make agitation against this social discrimination. Something like that. Okay, thank you.
Thank you so much. Thank you for having me. Thank you very much. Bye-bye.
Okay, one announcement is there. We are passing an attendance sheet. So please mark your signature in the attendance sheet, and if any, please verify it also, because if any corrections is there, please make corrections in that sheet itself. Okay, and please return by after tea break. Now we break for tea. Okay. So I invite Dr. Sabu Thomas sir also to receive our token of appreciation. Okay, thank you, sir. And we can break for a tea break. 5 minutes, please. Cited.
Okay, our Justice Chandra sir was sitting along with us. He was listening all the sessions here. So I think he will respond, not now, through online tomorrow. Okay. Thank you.
So please join by 4:20. Dear all, inviting your attention please. For tomorrow's session, we had, you have to put questions because tomorrow's sessions, there is a former Chief Secretary will be taking session based on the questions you had already put in the group. So please make sure that all the students are making questions for tomorrow's discussion. Okay, now we can go to today's third technical session, equity, justice and governance. So it is my great pleasure to welcome Dr. Abhilash Babu, Registrar of Sri Narayana Open University, as the chair of this session. Sir, please. So as an introduction, he has served formerly as Director and Associate Professor in MG University and as an Assistant Professor in Dr. B.R. Ambedkar University, Lucknow. With his rich academic and administrative experience, we are honored to have him to guide this session today. Warm welcome, sir. So, we are having two distinguished presenters with us for today's session. First, we warmly welcome Dr. Sanam Sadanandan. Is he, sir, am I audible, sir?
Yes, I can hear.
Dr. Sanam Sadanandan, author who had published 120 articles in Malayalam and 2 books, and currently serving as head of the Department of Political Science at MES Zambi College, Kodungalur. He is widely known for his insightful writings on contemporary politics, society, and media. He also participates in television discussion with regards to public issues. So on behalf of each and every one present here, I extend a warm welcome, sir. Next, we welcome Srinish TV. Sir, please. Assistant Professor and Head, Department of Political Science, Sri Narayana College, Kannur. So his work focuses on Indian polity and decentralized governance, and research areas include decentralization, governance, social justice. A warm welcome, sir. Once again, warm welcome to all the distinguished experts. And now I invite Dr. Abhilash Babu, the chair, to begin the proceedings. Thank you.
Good afternoon to all of you. I am very much delighted to be a part of this annual memorial lecture on Ambedkar and national seminar on constitutional morality and vision of Dr. B.R. Ambedkar. We have, I welcome all of you to this technical session on growth, equity, and equity, justice, and governance. We have 2 wonderful presentations ahead. First presentation is by Srinish TV. He is an assistant professor at Political Science Department, Sri Narayana College, Kannur. He will be speaking on the limits of political democracy, Ambedkar's conception of representation and minority underrepresentation in India's electoral system. So he will be speaking on the limits of electoral democracy, especially limitations of electoral representation in India, and he will see this development through the lens of Ambedkar's political thought and his philosophy. His major arguments are: Ambedkar did not view democracy merely as a system of elections or representative institutions, but as a broader social arrangement grounded in liberty, equality, and fraternity. He will be analyzing Ambedkar's critique of formal democracy and highlights his insistence on social democracy as the foundation of meaningful representation. And the second presentation is by Dr. Sanan C. Sadanand Kumar, who is serving as a Vice Principal and faculty member at the Department of Political Science, MES Asmabi College, Kodungalur. He did his PhD in 2020 from Mahatma Gandhi University, MPhil from JNU, New Delhi, and an MA in International Relations from MG University. He has published he has published many articles in academic journals as well as, popular Malayalam magazines, and he is also a panelist in many channels, visual media, and he is a member of different academic bodies. So he will be speaking on equity, justice, and governance, an Indian perspective. He is basically discussing on the interrelationship between equity, justice, and governance, and he will be examining the interrelationship of these concepts within the Indian context. He argues that moving beyond formal equality, India has adopted equity-driven measures such as reservation policies and welfare programs to ensure inclusive development. It is not enough. The governance needs to address the deeper inequalities such as caste, gender, region, and income. I welcome both of these presenters to this technical session, and I invite Sri Srinish TV to present his paper on the limits of political democracy, Ambedkar's conception of representation, and minority underrepresentation in India's electoral system. You have 20 minutes.
Thank you, sir. Good evening to all. Myself, Srinish TV. Respected chair and other dignitaries on end of the dais. My paper titled as The Limits of Political Democracy, Ambedkar's conception of representation and minorities underrepresentation in India's electoral system. So first, I would like to start with Ambedkar definition of democracy. Ambedkar defines democracy is not merely a form of government. It is primarily a mode of associated living, of conjoint communicated experience. It is essentially an attitude of respect and reverence towards fellow men. This is the simple definition of Dr. B.R. Ambedkar. In modern political theory, democracy is often equated with electoral representation, periodic elections, and majority rule. However, Dr. B.R. Ambedkar offered a deeper and more critical understanding of democracy. For him, democracy was not merely a form of government, but a mode of associated living rooted in social relations. Dr. B.R. Ambedkar's perspective on representation is one of the most original and radical contribution to democratic theory in modern India. He famously warned that political democracy cannot survive without social democracy. He argued that a society marked by inequality, especially caste hierarchy, cannot sustain genuine democratic representation. So, his main concern is how to secure genuine political power for socially oppressed groups, especially depressed classes in a power system. He consistently argued that formal political equality is meaningless without mechanisms ensuring substantive representation. And during 1917 onwards, Ambedkar made many efforts to radicalize the representative concept of democracy in India. During 1990, he made a recommendation before the Southborough Committee, and that recommendation laid the theoretical foundation of his thoughts on democracy. He argued popular government must ensure not only the representation of opinions but also the representation of persons. So here Ambedkar clearly criticized or problematized the concept of liberal democracy. In his vision, democracy is not merely a representation of opinion, but also it is a representation of persons. Ambedkar conceptualizes the theory of representation in Indian context. In a deeply hierarchical society like India, social divisions, particularly caste, creates an isolated and antagonistic groups lacking what he termed like-mindedness. Unlike Western society, where social mobility and interaction facilitate democratic functioning, in Indian society was marked by a rigid segregation, untouchability, and other caste evils. Therefore, a simple territorial or majoritarian system of representation would inevitably result in the domination of a powerful social groups. Ambedkar thus rejected the idea that a representative chosen by a majority could adequately represent all interests within the constituency. For him, representation had to be group sensitive and socially grounded, not merely a territorially organized. He advocated for communal representation. Communal representation is a necessary institutional safeguard. In his view, communal representation was not about dividing society, but about recognizing existing divisions and preventing their oppressive consequences. He argued that minorities, especially depressed classes, could not rely on upper caste representatives to articulate their grievances, as their experiences were unique and deeply rooted in social exclusion. Therefore, only members of these depressed communities could truly represent their interest. In this sense, communal representation was an instrument of political self-determination within a plural society. Importantly, Ambedkar also offered a sophisticated defense against the criticism that communal electorate would perpetuate divisions. He argued that by bringing representative of different communities together in legislative bodies, such arrangement could such arrangement could actually promote interaction, reshape attitudes, and ultimately contribute to the erosion of social barriers. His report on evidence before Southborough Committee on Franchise provided a detailed account of working of democracy and electoral representation in India. Later in 1928, B.R. Ambedkar cooperated with the Simon Commission and submitted a comprehensive memorandum in which he demanded separate electorates and reserved seats for the depressed classes in the provincial legislative councils. And also in first and second roundtable conference, Ambedkar sharpened his position on electoral representation. He demanded separate electorate for depressed classes similar to those granted in other minorities. So in 1919 to 1950, we can see Ambedkar deliberately put his idea or Ambedkar deepened his vision of democracy. In Southborough Committee, he elaborated the idea of democracy, and also he made his comments or his recommendations in Simon Commission, roundtable conferences, and finally in Constituent Assembly debates. B.R. Ambedkar had a deeply enlightened vision of democracy. In his opinion, real democracy in India can succeed only when the problems of caste is effectively addressed. He viewed caste as a system of social division that produces greater inequality, thereby undermining the principle of liberty and fraternity. In such an unequal social order, genuine democracy cannot take root. So, in this Ambedkar viewpoint, finally in our constitution promoted certain reservation of seats for scheduled caste and scheduled tribes community, and at present I think in our Lok Sabha, especially the House of the People, there are 84 seats are reserved for scheduled caste and 47 seats are scheduled tribes. So this is the context. Now I am making another point. What is the situation of minorities, especially the Muslim communities in India's electoral representation? So I would like to narrate my point is the under-representation of minorities in India's electoral representation, especially the Muslims. Over the past 75 years, India has established a functioning electoral democracy grounded in key principles such as universal adult franchise, periodical elections, and formal equality in the right to contest election and hold public office, etc. However, this political democracy continues to face a significant challenge. Despite these guarantees of equality, the country's largest minority, Muslims, remains markedly underrepresented in legislative bodies, revealing a gap between formal democratic ideals and substantive political inclusion. Despite constituting a significant share of population, Muslims have often had disproportionately low representation in parliament and state assemblies. This is not merely a numerical issue, but reflects the structural barriers within the electoral system of our country. The post system tends to favor majority consolidation, that is FPTP, that favors majority consolidation, where candidates can win without securing broad-based support. As a result, dispersed minorities struggle to translate their democratic presence into political power. So please look this slide. This table highlights the persistent underrepresentation of Muslims in the Lok Sabha across successive general election. From the very first election onwards, the proportion of Muslim members of parliament has remained consistently low, rarely reaching even 10% of total strength of Lok Sabha. Despite Muslims constituting a significant larger share of India's population, so nearly in our Lok Sabha, in the last 2024, nearly 5% of the MPs are elected from Muslim community, and their share of total population is in the 2011 census we can find 15%, more than 15%. So here is the relevance of Ambedkar idea of representation, the population and participation. So I am concluding. In conclusion, the continuing debates on representation, whether in the context of women's reservation in Lok Sabha or the persistent underrepresentation of various marginalized community, reveal the unfinished task of Indian democracy. While the constitutional framework has established the foundations of political democracy through universal franchise and electoral competition, it has not fully translated into substantive and inclusive representation. The persistent underrepresentation of minorities, despite decades of democratic practices, underscore the limitations of the system, limitations of our system that relies solely on procedural equality. So it calls for a deeper thinking of democratic institution and practices in line with Ambedkar idea of democracy. Thank you.
Thank you, sir, for concluding within the well ahead before the time limit. Now I invite Dr. Sanansi Sadanand Kumar for his presentation on equity, justice and governance, an Indian perspective. Sir, please.
Hello.
Yes, sir. You are audible.
First of all, I would like to thank Chair for the invitation. And I know the time constraints of this seminar. We are in the concluding of the last session of this 1 day, 2 days seminar. And I directly enter into my paper. And as Chair mentioned about the title of my paper, it's about equity, justice, and governance from Indian perspective. In this paper, I just go into the basic ideas, which means what about the idea of equity, idea of justice, and good governance, and what about how these ideas work in India. I mean, the major policies or the efforts made by the Indian government to just time to time to implement these basic ideas, and then look into the challenges we faced or we are facing by implementing or discussing these principles. These are the three main concerns of this paper. And what about the idea of equity? Equity in the Indian context. Generally, in India, especially in the public debates, like the debates in the media or debates in other informal structures other than the academic circles, it generally use the term equity along with equality. I still remember last week I hear a discussion about the caste based suicide in Kerala and regarding things. And one delegate was who representing a right wing organization, and he argues that reservation is, as you know, what is reservation, and he said, according to Article 14 of the Indian Constitution, it's called equality before law. And Article 15 is equal, no discrimination on the basis of religion, race, caste, sex. Then he pointed out the idea that no discrimination on the basis of caste, which means even the Indian constitution is also talks about the caste, which means no discrimination on the basis of caste. Then that kind of intellectuals, they totally negate or discard the idea of reservation on the basis of the constitution itself. That's an irony. We are talking about Dr. B.R. Ambedkar, we're talking about the constitution and justice kind of things. So first we need to understand the basic idea of equity in order to understand the Indian constitution. So, and the basic principles of equity, I only point out three basic things. First one is inclusivity. Inclusivity, as you know, I just give you an example. For example, it's a 100-meter race, and 4 or 5 students are participating in it. And the first student running towards a synthetic track, a second one towards a road, third one in a muddy road, and the fourth one in a sand. In a case, we can say that all are running the same distance, but their situation is quite different. So, in order to address these unequal situations, we need to understand the basic realities. That called the inclusivity of the idea of equity. And generally, we call equity is means based on fairness and justice. And as with the last presentation, also we discussed about the idea of justice. As we know, in case of India, social, economic, and political justice. And one thing very crucial, we always look into the placing of the orders. First is social, then economic, and third one is political justice. And another one, the resources, the distribution of resources, the allocation of resources. Definitely give prioritize towards the marginalized and vulnerable groups. Only on the base of these principles we can achieve the principle of equity. I'm only talking about the three basic things, but without understanding this basic idea of equity, we can enter into the other debates of democracy. And the socio-economic dimensions of equity, as we know, the education access to education, and the economic redistribution, a healthcare equality. Healthcare, as we know, is not only about the affordable of healthcare, but also quality of healthcare. That's a very crucial thing, and the gender parity. So these are the basic socio-economic dimensions of equity. What are the challenges in India? I directly enter into the Indian context. We are talking about equity and the constitution and the rights and Ambedkar, but the Indian situation is quite different. As we know, the number of politicians in India recently argued that there is no need for further reservations like that. So, what are the Indian situation? As we know, in India, the regional disparities are high, the uneven development across India. And the last 2 days, we are discussing about the things that happening in the Indian Parliament and the division between the southern states and northern states, and development or underdevelopment kind of distribution of power sky like that. So, in that kind of regional disparities are existing in Indian society, and that's one regional and that's major challenge in regarding the idea of equity. Another one, the social stratification. As we know, the India is a multi-religious, multi-linguist, or multi kind of thing. But the main issue here is that the deep-rooted caste system and the class divisions in the society. As we know, the caste discrimination is a reality in India. We witnessed a number of suicides in the prestigious Indian education institutions. Last we witnessed one even in Kerala. So the caste discrimination is a reality in India. So that is a fact. Third one, the policy implementation. And the equity level of policies are implemented by the system, by the bureaucrats, or by the other political authorities. But whatever the system in India, the level of corruption, inefficiencies, or bureaucratic hurdles. So, the effective execution of the welfare schemes, that's another major challenge in India. And another one, the institutional bias itself. The Indian system itself, in a way, is historical biases within the system. You can see that in case of the judiciary, you can see that in the education system. Just look into the number of the underprivileged sections, or the what I say, the marginalized sections in the mainstream, like in the media or in the higher education system or in the judiciary. So even the entire the system is not still in the halls of that caste system. That's all the system, the conservative Indian system. And then the second point. So first I discussed about the equity and how the challenges are faced in India. And second one, the Indian justice in Indian legal system. As I think the previous papers or Sundays talks about the idea of justice, we are talking about social justice, economic justice, and political justice. I already mentioned about the importance of social justice, because without achieving social justice, there is the economic justice and political justice are secondary and tertiary things. That is a reality. Unfortunately, many of our organizations or intellectuals are talking about political justice only, get a representation in the house or right to vote. That is not the enough justice. Justice starts with the social justice. That is a key point here. And as we know, how the system of justice or the justice mentioned in the constitution, I only pointed out three examples here. Definitely by the Constitution of India, fundamental rights, as we know, right to equality, right to freedom, right to religion, etc., etc. It's also mentioned in the part 4 of the Constitution, the BSP, Directive Principles of State Policy, progressive principle, liberal principles, and other principles. And in the judiciary, the role of judiciary is very crucial here. In India, the in many occasions, judiciary act as the guardian of the constitution, like the judicial review, and many times court intervene into the orders issued by the legislature or executive, or orders issued by the order or laws passed by the legislature. This intervention of court is very crucial here. But then, okay, then key judicial and legislative measures. I only point out three things. How the system try to implement the justice in India. As we know, this is a broad topic. We need to study a number of topics here. I only point out three here. First one, the reservation policies. Generally, a number of discussions are now going on reservation issues, reservation policy, whether we need reservation, the further reservation is need or not. That is another question of debate. And many intellectuals in India talking about the meritocracy. But the stand here is that, as we know about the situation of India now, the foundation of the idea of reservation is quite different. So my stand is that in not talking about non-criminal or criminal kind of things in India, the caste is it has a historical root. Can't judge things within the present. That's my the point here. Another thing, the public interest litigations. In case of India, the role of these public interest litigations, like initiated by activists, NGOs, that's also play a crucial role in India for a number of reasons, like ensuring justice for any human rights cases, also a number of human rights violations, like environmental cases. Also, we can see the role of effective role of public interest litigations. And another one, the system initiated by a number of anti-discriminatory laws, like the Civil Rights Act, Equal Remuneration Act, etc., etc. But still, there are not present situation in India. As we know, even though these kind of measures are there, the justice is very much in India. Um, we cannot take that India is a full-fledged democracy, because we lacking a number of things, especially implementation of the social democracy, economic democracy, and political democracy. And what about the governance in India? Good governance in India. Generally, we are talking about in a democracy, good governance is a part and parcel of the system of democracy. And as we know, the transparency is there, it should be transparency is there, accountability, participation, and rule of law. I'm not entering into the points. But in case of India, I just point out 4 points, four major features only. So decentralization. In a way, we can see it can quote then efforts, a successful effort in case of decentralization, the successful implementation of Panchayat Raj system by the 73rd and 74th Amendment Act, and how it successfully can involve, it can ensure the involvement of communities in decision making and process like that. Another positive thing about the e-governance. like the digital platforms, Aadhaar or Digital India. Not talking that these that's a perfect inform. Still, a number of issues are there, like the digital divide is very visible in India. Data protection is another major concern for India. But still, I'm talking about, in a way, we can say that good governance is, the government is, in a way, to good governance is, and the one is e-governance. Third one, the policy frameworks, which means the policies implemented by governments time day by time, like the MGNR EGA, Mahatma Gandhi National Rural Employment Act, like that. And in a way, the governments can make a bridge a gap in employment, education, and social welfare. Another one, judiciary's role. Here also, the role of judiciary is very crucial. Um, as we know, in most or the many occasions, not all occasions, many occasions, in Indian judiciary act as the guardian of the constitution or the protector of the constitution. So, in this way, we can say that the all for only once again I pointed out that I only point out 4 points, 4 points only here, and the challenges in modern governance in India. The first thing, the political interference. The first or the main one of the major concern about the India is that the frequent political meddling of administrative processes, like the involvement of the bureaucrats or the involvement of the politicians or involvement of the many other extra governmental agencies also, that very much negatively affect the governance system of India. Another one, corruption, as we know. Even though we are talking about transparency, governance kind of things, still corruption is part and parcel of the Indian system, administrative system. Once, as our former Prime Minister Rajiv Gandhi mentions, if you spend 1 rupee, only 25 paise reach to the bottom level. It's like that. So about the 75 percentage of the money. So I don't know if that's a correct estimate regarding the present situation, but still corruption is a it's in reality in Indian context. Another one, in inefficiency of the system. Um, the system is overburdened by a number of things, like the increasing population and the bureaucratic red tapeism within the bureaucracy. So the decision-making process is delaying in many aspects. So, the main point is that when we are talking about equity, justice, good governance, thus our system is not that much efficient to cope up with these ideas, to implement much policies and reforms for these things. And the last one, the inclusivity gaps. After the independence from 1947, we are still standing in 2026. About the situation of India, as I mentioned earlier, the caste system is still exists in India. I'm not talking about the caste system, but about the atrocities on the base of caste and the suicides on the base of caste. And caste is a reality. So, marginalized groups still face barriers to representation and access, even though we can technically speaking that they get representation in the form of political representation, in the form of scholarships, in the form of reservation of jobs, but still the inclusivity gap is still in India. So, in order to face this inclusivity gap, we need to address the entire address the ideas of the constitution. I conclude my presentation by pointing out one more point. So we are generally talking about an idea of economic growth and justice. Generally, as we are living in a neoliberal economic domain, and we are talking about the withdrawal of the state from the key service sectors like education, from health, etc., and etc. Then what about the idea of justice? We are crying for social economic growth, and we stand for justice. And so the need to address the idea of economic growth and the idea of justice. So we need to address 4 points. First one, the inclusive development. Even though we need economic growth, that is a reality, but still strategies like to skill training, small incentive for to bridge the gap between the economic progress and socio-economic empowerment. Another one, the environmental responsibility. As we know, many of these marginalized sections are live along with the nature, and many of these projects for economic growth are making profit on nature. So it will many occasions it create displacement of the marginalized sections. So we need sustainable models of development on the same time to protect the resources and the um, interest of these vulnerable sections. Another point is income disparities. As we know, the new economic system, the number of billionaires are increasing day by day, but on the same time, it creates a huge gap between the rich, the haves, and the have-not. So the income disparity is another point of concern, especially in the new economic domains. And the last one, right-based framework. So integrating justice principles, that is an important thing. So the economic policies align with constitutional commitments. So the point here is that the constitutional commitments are the real points which need to uphold in the present society. Even the changing governments implement a number of policies, as you know, the last few days in Parliament, a number of bills are introducing, passing. What we don't know what about the future of that bills and what will happen to the Indian polity after years or after some months. But still, the thing is that we need to uphold the ideas of the constitution because constitution is the basic law of the land, and the idea of India still exists mainly because of the constitution framed by Dr. B.R. Ambedkar. As we are talking about Dr. Ambedkar, we heard about the memorial lecture by Dr. Justice Chandru. So, by concluding this paper, I can argue that we need to uphold the ideas of basic ideas of a constitution on basis of only on the basis of that thing we can ensure an equitable and a justice society in India. Thank you.
Thank you, Sanan sir. This session, technical session on equity, justice and governance is, in my view, is highly befitting to the ethos and the spirits of Kerala Institute of Local Administration, which is focusing on the local governance and local democracy. And we had two wonderful presentations. One is on equity, justice and governance by Sanan sir, and the second one is talking about the limits of political democracy, Ambedkar's conception of representation. So these both presentations have given us a scope for widening our idea of democracy. Both are, close in their conception, and both speakers, they have broadly focused on one theme, that is inclusion or inclusivity. The first speaker, Srinish TV, he was talking on the limits of political democracy and the issues of representation in the independent Indian democracy. He is also talking about the issues of challenges of inclusion, that makes democracy efficient and fruitful. The second one, Sanan sir, he has used a different lens. He has used the lens of development theory to discuss the issues of or connecting the concepts of equity, justice and governance. Thank you for both the speakers. Now this is a time for the floor is open for question answer. We have you can take we have 10 more minutes for the question answer session. And the first speaker, Sri Srinish TV, he has already left the floor due to, he has to rush for his bus. And now you can ask questions to Dr. Saran C. Sanand Kumar. Please.
Any questions? So shall we wind up? Okay. Okay, sir. Any concluding remarks?
Okay. Now we are concluding this technical session, and thank you for the organizers, especially Dr. Binuraj, for inviting me to this seminar. And this also invokes lots of memories about my days in KILA at Trichur. And Binraj and Dr. Amrudaraj, we are also from the same institution, Mahatma Gandhi University School of Gandhian Thought and Development Studies. This is also a big opportunity to meet my, colleagues. Thank you for all the participants, and thank you to the speakers for your thoughtful, wonderful presentations. I declare this session as concluded. Thank you.
I invite Ms. Shabana to deliver vote of thanks.
Respected Chair Dr. Abhilash Babu, distinguished speakers Dr. Sanand Sadanandan and Srinish TV, esteemed delegates, faculty and dear friends, on behalf of the Dr. B.R. Ambedkar International Academic Chair, KILA, I extend our greatest gratitude to everyone who made this session on equity, justice and governance truly enlightening. To our chair, Dr. Abhilash Babu, thank you for steering the session with such clarity and insight. Your moderation ensured that Baba Saheb's ideals remained at the center of our discussions. To our eminent presenters, Dr. Sanand Sadanandan and Srinish TV, thank you for your thought-provoking presentations. You brought depth and nuance to how equity, justice, and governance are not just administrative ideals, but living principles that must reach the last person in society. This theme echoes Baba Saheb's core vision that governance must ensure social, economic, and political justice for all, and that constitutional morality is the soul of democracy. You have helped us connect his ideas to today's challenges. Thanks to all participants for making this session meaningful. Let us take these ideas back to our work and communities. Thank you. I invite Sudeshan sir to present a small token of appreciation to Dr. Abhilash Babu. Once again, thanks to all.
Dear all, some reminders and announcements are there. Reminder is about questions for tomorrow's sessions. That is in the group we had already requested to put questions for tomorrow's discussions. That is for session handled by Sri Vijayanda sir. Okay, so kindly put questions at the earliest before 6 because we have to consolidate and send it to sir. And there is announcement is tomorrow's session we will start at sharp 9:30 a.m. and requesting all the participants to join in the seminar hall by 9:20 a.m. Okay, and now we have a short break, and after half an hour, a tea break, half an hour tea break. That is by 5:45 we can join again for a music flute concert which is performed by Sri Mithun. So please all of you join at this hall itself by 5:45.